included in group 1 matter. It is of group 7, my lord. Item number 74. My lord, item number 107 to 110 is analogous matter. It should be included after that matter, my lord. All are analogous matter, my lord. My lord. Item number 74. It is group 7.
My lord, may I be permitted to mention one matter? My lord, group 1 land matter, it may be included in the daily list group 1 heading. My lord, there is an urgency. My lord, in this matter, previously a writ petition was disposed of by your lordship, directing that a minor is not entitled to land. That has been set aside because there is a provision in the Land Acquisition Act that minor is entitled to land also after the acquisition. So that order has been set aside. Thereafter, they again considered, and on the same ground, they have rejected my prayer and said that you are not entitled to. I filed a writ petition, my lord. I'm suffering from long back, my lord. My lord, can you daily list, my lord?
My lord, with regard to that matter, my lord, where the 2 writ petitions have been filed. In the first writ petition, my lord, the land matter. My lord, first writ petition, your lordship directed the matter to be considered by the special land acquisition officer. He considered the matter. After that, the second writ petition has been filed. They filed again certain objections, and thereafter your lordship again directed them to file the affidavit in opposition, but they have not used it. This is the matter, my lord, where the affidavit opposition was directed to be filed on 25th January. My lord, kindly, my lord.
May I have lordship's kind leave, my lord, to mention a matter? My lord, lordship was pleased to hear the matter on multiple occasions. As a matter of fact, I also concluded my argument.
It's a hearing matter.
Well, yes, no, Mr. Noyanchand Biani is appearing in the other side.
In this matter, Mr. Biani is appearing for DSDA lordship, but this week's lordship, he has done.
No, I am not saying this week.
It's in the
Any day.
list.
My lord, last occasion direction was that, my lord, the matter will appear fairly at the top.
Is it in the monthly list?
Yes, it's in the monthly.
Daily list.
So, my lord,
Supplementary.
My lord,
grateful, my lord. Any day convenient to your lordship, my lord.
my lord, may I mention one matter for updatation? The matter from monthly list to daily list. My lord, item number 936 of monthly list. My lord, the petitioner is a senior citizen aggrieved against the inaction of the part of the Haldia Development Authority for not granting any compensation, and they have taking possessions our land, petitioner's land, and service. They did not give me of service. That is a
All these matters, is the other side put on notice?
yes, my lord. It is for the as listed motion. It will
Give
come.
the number, give the number. Yes.
Thank you.
My lord,
971 was mentioned earlier twice, my lord. Had been cleared. I think the matter would be included afterwards.
It's a hearing matter.
No, motion.
Motion, give the number.
my lord, contempt matter, my lord, may I mention?
Give the number.
I'm grateful, my lord. May I be allowed to mention, my lord, in this 2 matter, my lord? Both the items,
Applications, give the numbers.
both the items are running in the monthly list, my lord. Kindly allow these 2 writ petitions, my lord,
What is your
because
urgency, sir?
direction was given to include in the matter in the supplementary list. Kindly allow the, my lord.
My lord, may I be permitted to mention a matter?
Supplementary list, দেওয়ার জন্য আছে।
The matter related to allotment of sand block. It is going to be allocated in favor of the property.
Item number 971 to mention a matter. In this matter, it was mentioned earlier before vacation, and your lordship told us to occur before after vacation.
It's a hearing matter?
No, ma'am, it's a group 1 matter, and we are praying for inclusion, for
is your
urgency of the
urgency?
inclusion. Sorry, ma'am.
What is your urgency?
Ma'am, urgency was the respondent was claiming unlawfully for a mutation purpose. The
Yes.
amount
Please repeat.
the respondent in this matter is claiming unlawful sum of rupees 20,48,000 for mutation purpose from our petition.
So it's under the block land and land reform.
Yes, ma'am.
It's by the
Yes, ma'am.
BLLR.
Yes, ma'am.
This code doesn't have determination at all. Please find out. It's under the specified act. It's under the Land Reforms Act.
Yes, ma'am.
You have to approach the appropriate forum. This code doesn't have jurisdiction.
But my lord, it was mentioned earlier, and
Maybe,
your lordship
but this code, maybe you did not state this earlier. If it is under the specified act, the Land Reforms Act, this code doesn't have jurisdiction. So please check and come back.
My lord, item number 917 of your lordship's monthly combined list. My lord, this matter, there was a sand block, my lord, allotted to me, and an order of suspension and show cause was issued by the DA. My lord, your lordship in the earlier writ petition was pleased to direct the ADM and LRO to decide the show cause. That now he has declined to decide because the DM has passed the order. Second round application, it will take only 1 minute to renew the direction to the DM. It will not take more than
Give
2
the
minutes.
number,
of your
give the
lord.
number, please.
Can it appear to be mentioned, my lord? Because it's a very short matter.
Not to be mentioned, it will appear.
Because 4 years I am suffering this order of suspension.
Maybe give the number, I'll include it.
Grateful to lord.
Give the number.
Madam, I'm praying for mention.
Vacating application. Vacating of my lord's order.
Vacating of
My lord's interim order application.
interim order. Give the number.
My lord, I
It's
have,
appearing on some date.
no, my lord, it has been given date by tomorrow, my lord. Supposed to appear tomorrow. I have served notice, my lord, also copy my.
My lord, I have just mentioned this.
যদি কালকে হয় তাহলে ওটা অ্যাড করো অ্যাপ্লিকেশনটা অ্যাড করো যদি কালকে হিয়ারিং যদি মোশনে থেকে থাকে তাহলে এটা ওটার সাথে অ্যাড করো
No, main
My lord,
motion.
my lord, I have just, my lord, I
praying
have
for
just
mention.
mentioned that matter that is against Holdia municipal. My lord, the affidavit of service has been filed. Thank you, madam.
But I'm praying for mention, my lord, my land has been acquired by the government of West Bengal. My lord. Thereafter, another land has been allotted in my name by the, but my lord, the respondent authority not handed over that land, my lord, to me, my lord. What is serial number?
Madam, my lord, the petitioner was a senior citizen and she passed away on 3rd December 2020. And my lord, thereafter the substitution application was filed. And my lord, basically the ingress and egress of the petitioner's house is being.
Substitution application has been allowed.
My lord, actually, since this is a rich petition, my lord has the.
It has, you filed an application, isn't it? So, application, substitution.
Grateful.
May I permit it to?
My lord,
petitioner,
I
madam,
may be
ma'am?
allowed to mention my
Substitution has
case
been
is
taken.
appearing in the monthly list 1044 and I'm praying for inclusion in the daily list. It is a land acquisition matter.
What
and
is your urgency,
compensation
sir?
for- It is a short hearing only.
Maybe, what is your urgency?
Urgency is I need compensation. Land has already been acquired.
Give the number.
Ma'am, may I permit it to
Item
mention?
1025 of your combined list, Lord. This is that matter where we have completed our submissions. Mr. Siddiqui was to comment submissions, Lord. Matter was last directed to appear on 10th May at 3:30. Lord, as Lord, hearing matter in the supplementary list, Mr. Basu was reading me. But that Salt Lake matter, Lord, we have completed our submissions.
Give the number.
So any day it may appear in the supplementary list. Monthly list, supplementary to aste hobe. Supplementary ache?
Please
Ma'am, may I,
find out, sir.
ma'am, may I
Don't
permit it
mention.
to?
One matter, my lord. On it, PDF submission 3 times.
Huh?
Matter was updated. Not
Supplementary
submitted.
ache?
Matter
আজকে supplementary আছে?
relating to land acquisition.
No, it's not there in the supplementary list. দেখি দাও, list টা দাও।
Give the number.
Ma'am, may I permit it to mention a matter?
We have taken sufficient mention for a day, please, yes.
Ma'am,
you have
just
been
one,
waiting for
ma'am.
a long time, yes. Come back after a couple of days, please.
My lord,
Yes.
appearing as item number 323 of the monthly list. Your urgency is that, my lord, the land of the petitioner and the of the villagers has been used by the ECL and the village is suffering subsidence. On the report vacation, my lordship was pleased to update the matter, but
This is a PIL.
not PIL, my lord. The land of the petitioner, my lord, has been used by the ECL.
You say that the entire village is suffering.
My lord, maybe, but I have a personal right.
Give the number.
My lord,
Ma'am,
query
my
permit
matter is
has
very
been
much
suspended.
urgency, ma'am.
Yes.
My query permit has been suspended without assigning any receipt, my lord. The matter is running in
সকাল
your
থেকে
last monthly.
non-cooperation করে গেল।
The numbers, I will not upgrade the supplementary list matters. Let me make it very clear.
Ma'am, it's in very much urgency, ma'am, I'm having.
My lord, restoration, my lord.
Restoration, give the applicant. Come,
Ma'am,
why don't you
very-
come back tomorrow?
Ma'am, my matter is very much urgency, I'm having, ma'am.
Last occasion matter was updated, that could not be already.
All other mentionings tomorrow. Please,
Lord, Lord, I have checked up,
please call the days.
Lord, I have checked up the supplementary list.
On state was it was in the monthly list of my lord.
All these matters are in the monthly list, sir. They are not unlisted motions. They are all in the monthly list.
My matter
So
is
please
not
come
clear.
back tomorrow.
Lord, I have checked up the list. I have checked
Not
up the
in
list.
the-
No, in the list, it is printed that from 3:30 from item number 1003, it will be taken up. Look, this was the matter, Lord, which was appearing singly, Lord, in the
The
supplementary
monthly
list.
list, it's not in the supplementary.
No,
list.
not in the
Give the
supplementary
number.
list.
Yes, call the days list, please.
Supplementary.
Restoration, give the number. Yes, one day the heaven will not fall, sir. Come back tomorrow. Yes, days list. Please call the days list. Yes, who is appearing in the first item?
This repetition, my lord, is against the
Number one.
This will be against the initiation of a proceeding under section 10 of the West Bengal
Who
Highways
is
Act.
appearing for the respondents? Have you served copy of the order that was directed on the earlier occasion? Yes, have you served copy of the order?
Yes, copy has been served.
Copy has been served, so there is no need for extension of interim order any further.
Because, my lord, I have challenged the proceeding, my lord. Your lordship, kindly have a look at the first order. This order has been passed by the subdivisional officer who has no competency in the eye of law. Your lordship, kindly have a look at the section 10 of the.
Why did you make this submission on the previous date then? You want to prefer an appeal against the SDO's order?
No, I did not prefer. I told that no order has been passed, no order has been served. But my lord,
You have said that no order has been served, so I cannot prefer an appeal. That's why I'm before this court. So now copy of the order has been. It was your submission, sir. It will not be extended.
but your lordship, kindly have 22nd May order.
Yeah,
22nd.
same thing. The 10-3 order was
the
not
grievance
served on you. That's the grievance.
Well, challenge the initiation of the proceeding under section. Petitioner has challenged the initiation of the proceeding under section 10.
Yes, after that you have stated that 10-3 order was not served on you. So you are not able to prefer an appeal. So now that 10-3 order has been served on you, you are at liberty to prefer an appeal.
Well,
Interim order will not be extended.
in the order dated 22nd May 2023, the concerned authority exercising powers, last line. 22nd May order, last line.
Yes.
The concerned authority exercising powers under section 10(3) of the 97 is directed to serve a copy. But copy has been served by the subdivisional officer, not the competent authority.
Where are you reading this line? Where is this?
Well, order dated 22nd May,
22nd May, yes.
last line. The first page, last line. First page, last line.
First with the concerned authority.
Concerned authority exercising powers under section 10, subsection 3 of the 1964 Act is directed to serve a copy of the order passed by the competent authority.
So who has the
Authority is the executive magistrate. Your lordship, kindly have a look at the order. Permission. Section 10.
the concerned authority exercising power under 10(3)?
10.
That is the executive magistrate.
That is the magistrate. That is the magistrate.
Executive magistrate is the subdivisional officer. They are not different.
That is a subdivisional magistrate, but not subdivisional officer. That is a subdivisional magistrate, but not.
Whoever has served, sir, you have received, you are being technical. You have received a copy of the order, so you can prefer an appeal.
Well, these proceedings in the earlier occasion initiated by the subdivisional magistrate. Well, your lordship, kindly have a look.
Interim order will not be extended.
Well, subdivisional magistrate, that order has been that demolition order has been quashed by the subdivisional magistrate sometimes in the 1979.
Which order has been quashed?
This same order. I have annexed in the
So you
petition.
can prefer an appeal against this order.
No, my lord. Thereafter, what again? What happened? After that, my lord, after the subdivisional magistrate quashed the order of eviction in the respect of the self-same stall, which is the 64 years old. My lord, thereafter, railway authority claiming that the land is of the railway authority. Certificate proceeding was initiated against the certificate proceeding. A writ petition is pending, my lord, because this rule was been issued. Your lordship, kindly call for the record of the rule of 1980. Thereafter, my lord,
This matter to date has been fixed for extension of interim order. I am not hearing the matter on merits. Your only ground was you have not received a copy. Now that you have received a copy, interim order, that's the earlier order also. There is no question of extension. Heard learned counsels for the parties. Since admittedly, the order dated 17th May 2023, passed by the subdivisional officer, Raghunathpur, has been a copy of the order has been served upon the petitioner
this order has been served on 30th May.
in compliance with Yes, and today we are in June.
30th May.
Yes, today we are in June.
Yes.
And here the direction was on the subdivisional officer to serve. Order dated 29th May. Comma. The petitioner is at liberty to prefer an appeal against the said order in accordance with law.
No, without prejudice to the rights and contents of the petitioner do this petition, my lord.
To the,
Without prejudice to the rights and contents of the petitioner in this writ petition.
you can prefer a statutory appeal. So there is no
But
question. of without
I
prejudice.
challenge the proceeding itself.
This writ petition will be fixed for hearing. Today it's only for extension of interim
No,
order.
my lord, today, writ petition is pending, my lord, I have challenged the proceeding, my lord, your lordship, kindly consider this aspect only.
So there will be a hearing date on, in this writ petition.
Yes, my lord.
I'm not disposing of the writ petition at the moment. In compliance with the order passed by this court on 29th May 2023, comma. Paragraph in view of the above, there is no scope for extension of the interim order any further. Paragraph, let the writ petition appear under the heading Group 1 motion.
Another record in respect of the earlier proceeding,
On
earlier writ petition.
21st July.
My record of the earlier writ petition is called for, my lord, your lordship. That is the department, my lord, I could not trace out, my lord.
How is it necessary? File a
Well, it's
certified
necessary
copy.
because the in the same
Come on,
land.
the next day I'll consider, let me see.
Unless
21st July.
that writ petition is called for, my lord, your lordship, it would not be
Let
prudent
the
to.
state come prepared. Let me see what is there in this petition itself.
And my lord,
Next matter.
one more indulgence I get, my lord. I can prefer an appeal within the time limit is 15 days. Time limit is 15 days. So I have time.
I have stated in accordance with law.
So I have time. Your lordship
You
kindly.
still have time. So,
So your lordship kindly extend for a week only. No adverse flight can be taken by the authority within a period of 7 days from the filing of the appeal, my lord. Your lordship kindly pass this order.
Government land.
It is not a government land. My specific point, it is not a government land. It is a personal land,
No
completely
further
personal land.
Pass, prefer your appeal immediately.
But your lordship kindly pass it to that extent, my lord. Only for a week, my lord. No adverse flight can be taken by the authority. Your lordship kindly hear this. But this is not the private land, government land. This is a completely private land. I have purchased this land since in the year 1961.
I fixed 21st July. I fixed 21st July. Yes. No, interim order has not been extended. He'll prefer an appeal. Because today is only for extension of interim order.
Your lordship,
Come on the next day.
your lordship kindly,
Next
your lordship
matter.
kindly pass an order for a week only. No adverse flight can be taken up for a period of 1 week from the date of filing the paper in the appeal.
You have already got 10 days, more than 10 days. So please file immediately. No further.
Well, your lordship kindly, I shall file it tomorrow. But your lordship kindly.
If the appeal was pending, I could have passed an order. You have not yet filed the appeal. So file the appeal and come back. Next
From the date of preferring appeal, my lord.
No,
From the date of
next.
preferring appeal.
Prefer the appeal. You've not done that in the last 11, 12 days. It is lack of diligence on your part, sir. You're sitting tight on the order.
It is on the presumption that has been filed. I have challenged the proceeding, my lord.
Come back on the next day. Let us see. Next matter.
Item number 2. My lord, I beg to appear.
And appearing on behalf of the state, my lord. In earlier occasion, your lordship, my lord, directed, my lord, the executive engineer to submit report. My lord, my instruction in this, my lord, today it has not been filed upon, but it is with me. My lord, the executive engineer has directed the PLN LRO, my lord, to demarcate the land and submit a report. And the report has not yet been received. My lord, kindly see this.
If the report is not ready, you say.
My lord, the PLN report is not with me at present. Now kindly fix the date, my lord, I said. Kindly see, this is an account copy, my lord. I shall have only after getting the report of the PNRO.
Earlier, you say the land was not acquired.
Yes, madam.
Now you
thereafter-
again say the land was acquired.
Not acquired, not by the land department, acquisition department, madam. Yes,
So why don't you
special
come
area,
back with the comprehensive report, madam?
madam, I should submit, madam.
Let's come back with
Madam,
it.
in earlier occasion of the status.
The state is taking double stands.
Special land reforms officer, madam, the acquisition officer, madam, submitted the report, madam. That report is in the, I have submitted that report, the file, kindly see, madam. And thereafter, madam, now the executive engineer, madam, is ready to submit the report.
You have not submitted any report earlier.
The report of the special land acquisition officer, which has not been.
Did you receive any copy? No report was submitted earlier.
Madam, madam,
Please come back with a comprehensive report. Learned Counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph. Let the matter appear under the same heading. On 14 July. Please serve an advance copy.
Or in the event any advance copy is served, my lord, I am liberty be given to take the exception if any, my lord.
The state respondents are directed to serve an advance copy of the said report to the petitioner, and the petitioner is granted liberty to use an exception to the report, comma, if required. Therefore, let the matter appear. Next.
Number 3.
But I am for the state respondent in this matter.
My lord,
Mr.
Parthapratim Rai appearing on behalf of the petitioner, my lord.
Yes,
Affidavit service to. He's on his leg, my lord. He's just,
you're asking for an adjournment?
no. He's on his leg, my lord. Just now.
Passover cannot be granted in this court. Yes, please make your submission.
আর শুরু করে দাও না কি আছে মামলা
আমি কি করেছি আমি matter.
শুরু করে দাও
My lord,
Yes,
matter কি কোথায় জানি।
বললাম আমি বলতে পিটিশন
Affidavit service to দিয়ে দিয়েছি।
yes.
the land of the petitioner that was my lord acquired. For my lord this is my lord for the embankment proceedings. My lord without paying any compensation. Now my lord kindly considers
Was it acquired?
acquired. My lord, your lordship has
Petition says
recently
no-
passed, my
no
lord.
proceeding was initiated.
Yes, where?
Your law respondent number 8.
Your lordship had, my lord, recently passed, my lord, this order,
Your writ petition says that the land was utilized without acquiring.
utilized without acquired.
But
Lord,
now
my lord,
you say-
I beg to be corrected. Utilized, my lord, without acquired. No proceedings initiated, my lord, utilized.
Yes,
My lord, I lost my chain, my lord, since my lord, I was. Lordship had recently passed this order, my lord, similar, my lord, adjacent land.
yes. What are you asking for in this writ petition?
My lord, so, but the acquiring proceeding, my lord, is taken up, my lord, compensation is paid. Proper proceedings we initiated, my lord, and my lord, the land is acquired in a proper
Do
way.
you have a representation pending?
Yes. My lord, kindly considers, my lord, that order, my lord, the executive engineer was directly, my lord,
The representation is at page.
my lord, page 16, 17.
Both of them, they are similar. They are identical representations.
My lord, this is my lord. The next one, 16 one is of my lord, the irrigation and waterways department, Jala Sampad Bhavan. My lord, the effective representation is, my lord, the next one, my lord, executive
17.
engineer, 17.
Yes, Mr. Rahul?
Not your lordship, can you look to the fair first? Fair E.
Yes.
Is in the nature of mandamus commanding the respondent authorities to initiate appropriate application to pay. My learned friend, junior friend, he said, just inception is argument, the land has been acquired.
No, no.
Land has not.
He has made his corrections.
Yes. Your lordship, kindly come to paragraph 3. Paragraph 3.
Yes.
Your petitioner states that your lordship got it. On or about such and such, 2010, the executive engineer being the respondent number 8. There is no respondent number 8. Up to respondent number 7 is here. Without initiating proceeding whatsoever in the nature, forcibly, if anybody is taking position, there are law in the office that he could have very well proceeded. I hope and trust not the government will never recover the land by force. Definitely there should have been or could have been. There is a doubt whether land at all has been acquired or not.
It has not been acquired admittedly.
Not acquired.
It has
So
been
he said
utilized. He
forcibly
said.
acquired. He said forcibly acquired. He says
Forcibly
paragraph
took
3.
possession, not acquired.
I'm whatever means the possession, if
That
at all,
is utilization, not acquiring.
Lord, we do not know. We do not have any knowledge.
So
And
why
he has
don't you,
made the-
why
not-
don't
he has
you
made the-
consider the representation?
That can be done, but no respondent number 8, respondent number 7. He has asked.
My lord,
respondent
my lord,
number
I'm
8.
praying for a leave, my lord, to correct
Every
it.
paragraph, you've stated 8. 3, 4, 5.
But I beg to be corrected, my lord. Should have, my lord, checked it up.
Who has utilized the
Let
land?
the, I'll not go into merits. Let the seventh respondent decide the representation.
Executive engineer.
Yes,
If the land upon it is required, that has to be seen by the appropriate authority.
that is the executive
The
engineer.
LAO is the authority. If any land, your lordship knows the law better than me, lord. Your lordship knows it. If land is acquired, it has to be done by the LA.
Lordship,
If
land has to be if the land is at all utilized, that has to be ascertained first. After that only, my lord, the proceedings can be transferred to the LA.
Executive engineer say what is the actual position.
Let's see.
Okay, good.
Affidavit of service.
ওটাকে correction করে দাও।
Petitioners contend that their land has been utilized by the state respondents for construction of embankment at Moja Bagdanga, Bagdanga. But the land has neither been acquired, nor compensation paid to the petitioners for the same. Stop. The petitioners submitted a representation in this regard before the concerned authority on 2nd August 2021 and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the seventh respondent be directed to consider the representation in accordance with law.
Not where submit what he has to amend the cost title also.
Cost title নাই।
আরে তোমার এটাকে করো 8 তো নেই 8 নেই
Cost title নাই, paragraph।
প্যারাগ্রাফও করো ওখানেও এই 8 নম্বর তোমার কি আছে কেউ আছে 7
Cost
নম্বর
title need not be amended. Why does it have to? Because 7 is the executive engineer.
this is the representation of 21
Yes.
last annexure page 17 to the executive engineer, that is the
Let that be considered.
executive engineer কাক দিবি
In view of the above, the petition is disposed of, directing the seventh respondent to consider and dispose of the representation submitted by the petitioner dated such and such. Within 2 months, from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, in the event, no, not necessary. Let them consider. You can take this back. Disposed of it. একদম শুরুতে করুন, on prayer of the petitioners, liberty is granted to correct paragraphs 3, 4, and 5 of the writ petition by incorporating respondent number 7 instead of respondent number 8 stated there.
Great.
Correction to করতে হবে।
And number 4, my lord, I along with Mr. Das is appearing on behalf of the state.
I am for the petitioner, my lord. I served upon all the respondents, services effected.
Thank you. My lord, land has been demarcated,
Unauthorized construction, my lord,
was
was
found, my lord,
Private respondents.
served, my lord. Services effected.
this is the report, my lord.
Last two.
Not served. Where is it served?
My lord,
Abdul Mannan is out for delivery. Page 12.
my lord, the Ambia will be delivery confirmed. Last annexure, my lord, page 13.
Page 12.
Item received, right. Item back.
Out for delivery. Out for delivery.
তারপরে পাতা
My lord,
Please serve and
my lord.
So may I get back the report, my lord? No, শুনতে চাইবে না just.
since affidavit of service, since service upon the 8th respondent is not complete, let the matter stand over till 3rd July. Sufficient time for you?
My lord.
At number 5,
Lord, I beg to appeal, Lord, for the petition in this matter, Lord. May I file the affidavit of service.
Mr. Mondal, your affidavit?
Short matter, Lord. Lease deed, Lord, executed in my favor in 2018. Lord, 21 months, I was not granted any possession. For, Lord, whatever reasons they had. Lord, in December 2019, I was granted possession, and thereafter, Lord, the COVID had set in. Lord, I had made a representation indicating that the delay of this 41 total months may be extended because, Lord, invoking the force majeure clause. Lord, that has not been considered. Lord, kindly directs the authorities, Lord, so that they consider within a specified time, and I can, Lord, thereafter pursue my other remedies.
Yes, Mr. Mondal, Mr. Shah. Where is your representation?
My Lord, representation, page 89. Lord, page 90 is just the replica of page 89. Kindly,
It's a
Lord,
demand of justice. This is not a representation.
Lord, Lord, permits me then, Lord,
Please
to
file a
complete.
representation. Because the court cannot direct consideration of demand of justice.
Representation.
Affidavit of service. It is contended on behalf of the petitioner that being the highest bidder in the e-auction floated by the state respondents on June 12, 2017, the petitioner was granted long-term mining lease for a period of 5 years, with a deed of lease executed on
Lord, page 21 is the lease deed.
what is the date?
Lord, 16th of March, 2018.
Page
21, 21.
16th of March 2018. Possession of the plot in question was handed over to the petitioner on the date of possession,
Lord, 80, page 80 is the possession certificate, my lord.
80.
80.
It's not very legible. Is it 29th April?
Lord, 29th April 2019.
On 29th April 2019, stop. The petitioner was unable to carry on mining operation due to advent of the COVID-19 pandemic and seeks to submit a comprehensive representation before the concerned authority requesting extension of the deed of lease for a period of
41 months.
41 months, during which he was unable to carry on mining operation. Paragraph, it is submitted on behalf of the respondents. Who should consider the ADM? 6. That the sixth respondent be directed to consider the representation at the earliest, in accordance with law. Paragraph, in view of the above, the petition is disposed of in granting liberty to the petitioner to submit a comprehensive representation before the sixth respondent within 7 days. Within 7 days from date, stop. The sixth respondent is directed to consider and dispose of the representation within 1 month from the date of receipt thereof. Within 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Lord, only one thing, the writ of possession was on 24th of April. Although, my lord, I have obtained physical possession, I have stated that in paragraph 11 on December 11, 2019. Kindly, my lord, incorporates that, Lord. Paragraph 11, it's my statement.
Position is
Dispose of that.
The petitioner obtained physical possession. The petitioner obtained physical possession of the plot in question on December 11, 2019.
Great.
I have started with it is contended on behalf of the petitioner.
Great.
Number 6.
Time for the petition as far as. Well, evidence service be kept to the records.
Development is a party.
Lordship,
But copy has not been served.
I have missed. I am serving. Lordship.
Give me a
Copy. In course of day. Finally, this is applications for extension of the long-term mining lease. This is the second round of petition. My lord, kindly have a look. Firstly, Lordship, your Lordship's order on page 64. Page 64. And the Lordship, and the page 65. Lordship, there was a submission of the state respondent, second page. It was submitted that on behalf of the respondent that the fourth respondent be directed to consider the representation in accordance with law. The fourth respondent is the ADM. Lordship, kindly come the impugn order. Lordship, page 73. Page 73.
Yes.
On 23rd December 2022, applicant to the writ petition is present through learned lawyers such and such submitted a written notes of argument at the time of hearing, perused the same and observed that he has stressed upon the clause of force majeure as emphasized in the lease deed and accordingly prays for extension of 1 year. Peruse the office records. The lease is due to expire on 1st February 23 by order number such and such dated at the state government has granted extension till 31st May. That is, Lordship, the one notification was issued by the state government, and for this notification has been cited. to all the lease expiring till 30 April 2022, that is 31st May 2022. As such, this lease will expire 1st February 2023. No benefit of the order was available to the lessee. With the promulgation of the West Bengal Sand Mining Transportation, Storage and Sale rules, the existing lease are governed by virtue of Rule 3, Subclause 2. The question related to lapsing amalgamation transfer of existing lease are governed by the Rule 8AB. In absence of any specific authorization as to who will be authorized to consider such cases, it is evident that such power rests with the state government, that is Department of Industries, Commerce and Enterprises, Government of West Bengal, as per Rule 2, Subclause 27 of the said rule. Now it is further evident from the office record, the prayer regarding similar concern has already been sent to the Department of Industries, Commerce and Enterprises of the Government West Bengal of the District Magistrate, citing the ground of force majeure as the condition as emphasized in the deed. In one such cases, Mrs. Loknath state, after due consideration of the prayer, Department decided that certain such that the tenure of existing sand mining lease shall not be extended. In view of this, Lordship, my application is being refused. So my prayer is here, my submission, that since the ADM has no authority to decide this issue, as I have admitted the same fact, so therefore the ADM should have forwarded this matter before the state government. And Lordship, one thing is that citation was similar circumstances. I have not party in the proceeding. I have not concerned anyway. The similar circumstances. Who is the Loknath? Who is that? So Lordship, my representative should be considered by the state government. The respondent number 2 hearing. So this cannot be a reason order. Similar circumstances. What is similar circumstances? I have not been issued that order even.
Let us hear the state. Yes.
Your Lordship, if says the order he is not satisfied, passed by this, then it is an applicable order under section 51. It's an applicable order. Then why he has come before the court?
Applicable order is before the divisional commissioner. Here, mind is the order has been itself stated.
The order of the in terms of the order of the read court.
Let me finish.
Prefer an appeal under the provision.
Let me finish.
An applicable order.
Here, my lord, it has clearly stated that the authority is the Department of Industries. A divisional commissioner is the subordinate to them. So why should I go prefer before the divisional commissioner?
This is by the ADM DLLRO.
Lordship.
This order is passed in terms of the rules, 2016 rules. So it is appealable.
Lordship.
Rule 51.
In this respect, Lordship, kindly come. Rule 51.
Yes.
Then.
Yes.
Any person agreed by an order made by the district authority or any officer duly authorized by the district authority in exercise of the power conferred upon him by these rules may, within 30 days from the date of communication of the order to him, prefer an appeal against the order. So, Lordship, kindly, in this respect, Lordship, I am saying that there is no such provision for extension of interim order in this rule. So, the power which they have rejected, there is no such power.
The provision is in the deed of lease. Force
Lordship,
majeure
Lordship,
clause.
in this respect, Lordship, one thing I have kindly allow me to place one coordinate bench order. Lordship, kindly have a look. Unreported. Dichi. Lordship, in this order, Lordship, kindly come second page. Second page. I am Dichi. Second page. Lordship, kindly come the middle portion. By an order dated, Lordship has got by an order dated 20 September 2022, the respondent number 4 rejected the petitioner's application. This order is not applicable under Rule 51 of the relevant rules. There is no provision for extension of lease content in the rules. The impinging order was not passed in exercise of the power conferred by these rules. but in response to the direction passed by this court. Therefore, the writ petition is very much maintainable. In any event, the petitioner has raised different issues which can be best be agitated before this court. If the third, this is the contention.
Here, there is no different issue raised. Number one.
This order is also, this is the, also for extension of the order, extension of the lease. This is also the extension of lease. Whatever the allegation is there.
His whole area because of some antisocial activities.
Whatever it.
And then the facts of this writ petition and that petition
Lordship,
was quite different.
that was the-
And this order was produced before the lordship on last occasion, last Friday. There he represented.
Lordship, this is also, this is the order also for extension of the lease.
Different.
The factual Lordship, the factual aspects may be different, but the rule is the same. Factual aspect.
Once the order has been passed.
He cannot deny that the lease was granted in terms of this concession rule 2016.
Whatever it.
You have relied upon force majeure clause of the lease. That is the lease. Lease was granted in terms of the rules.
Lordship,
This is an order under the rules. I'll grant you liberty. The limitation period will be condoned and it will be heard by the appellate forum on merits. Yes?
Yes.
You'll file the appeal within 10 days?
15 days.
15 days? Affidavit of service. The petitioner is aggrieved by the order passed by the additional district magistrate and district land and land reforms officer on 23rd December 2022. Rejecting the prayer of the petitioner for extending the extension of the mining lease. Stop. Paragraph, the said order is amenable to appeal under Rule 51 of the West Bengal Mine and Minerals Concession Rules, 2016. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed as not maintainable. Paragraph, however, liberty is granted to the petitioner to approach the appropriate appellate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers the statutory appeal, within 10 days, you said?
15 days.
Within 15 days from date, the appellate forum shall deal with the appeal on merits upon condoning the delay in filing the same. The appellate forum is further requested to dispose of the appeal as expeditiously as the business of the forum would permit. There shall, however, be no arrest costs as in certified website.
Development has not been served. So kindly indicate that will
Sir,
be a copy.
I'm serving.
Let there be a recording.
No service was made at all.
No, no, sir.
It has been mistake. Initially,
On the affidavit service, it appears that
It is not sir. একদম শুরুতে করুন affidavit of service পরে।
Five.
The petitioner, you have served already?
No.
Undertakes to serve copy of the writ petition along with annexure thereto upon the 5th respondent in course of this day.
Lordship, I am serving.
Next.
Number 7. Lord, I'm for the state respondent.
Well, I appear for the private respondent on my instruction. This matter was mentioned and this is listed today.
Yes,
I am challenging the.
please take the microphone.
Page 29.
Please take the microphone.
Yes. Page 29.
Page?
Page 29. 29.
Yes. This is a 10-1 notice.
Removal,
The removal.
encroachment.
On the issue of the lots is the direction.
Yes, it's a 10-1 notice.
Yes, 10-1.
Also, that kind of loss is direction. Like that is kind of 27 year lots in past order. Have to consider the differences are made by not.
Yes.
That's why they notice the issue. While I am deciding that with the family my lord on my lord bamboo and with trally shaded construction, but I have
Your own
already
land?
removed that portion. And PWD wrote estate the land, and we are more than 20% they have for more than 30-40 years. I have the landless people. That's why we made representation that we are for the engage and they are getting correspondent number 8. I mean, I have already vacated that portion. That is my submission that my report.
Are you occupying PWD land?
PWD.
What is your right, title and interest in respect of the said land?
Landless person, and I am on more than 40 years are there.
That doesn't entitle you to continue?
Right, but once I
If this is a 10-1 notice,
Yes.
you will have your,
electricity bill and everything.
On the basis of the report of the PL concern.
you will be heard under section 10-3, you'll be given an opportunity of hearing.
Yes.
Yes?
Opportunity are given to me an opportunity for hearing before my lord, or my report be submitted. Whether my
No report is necessary at all, sir.
notice is there, my
Hearing was given, my lord.
No, no,
Yeah.
10-3, he will get the opportunity.
opportunity.
He will get the opportunity. This is absolutely premature.
10-3 is proceedings?
No,
No.
only
It has stopped at 10-1.
because of this writ petition. For that, I have mentioned this matter.
You will have an opportunity under 10-3, sir. Nothing further can be done.
But your lordship, I have been there for more than 40 years. However, I will.
Does that confer any right upon you?
There.
10-4 is also
The-
there.
Tarak Purun, report submitted on behalf of the state respondents is taken on record. Paragraph, the petitioners have challenged the notice issued under section 10-1 of the West Bengal Highways Act 1964. Paragraph. Heard learned counsels for the parties. Paragraph, pursuant to an order passed by this court on 28/8 November 2022 in WPA 5152 of 2022, directing the concerned authority to consider and dispose of the representation submitted by the petitioner therein. Within bracket, you are the private respondent.
Yes, I am.
Within bracket, the private respondent of the present writ petition. Private respondents. Comma, demarcation of the plots of land was made by the Block Land and Land Reforms Officer, and upon detection of encroachment therein, comma, notice under section 10-1 of the Act of 1964 was issued. Stop. Paragraph, the petitioners submit that they have been possessing the said plots for more than 40 years. Paragraph. Since proceeding under section 10 of the West Bengal Highways Act 1964 has been issued, comma, the proceeding be directed to be concluded within a stipulated time frame. Stop. The petitioners shall be afforded an opportunity of hearing by the concerned authority at the appropriate time. Paragraph. In view of the above, the writ petition is disposed of, directing the, yes, place your documents. Hearing includes everything.
No, not.
Aadhaar card doesn't confer any title upon you, sir.
And he is residing there more than 40 years. That has been recorded, your lordship. Kindly record also that it does not confer any right.
Not necessary at all.
His statement has been recorded by.
The assistant engineer,
Yes. Four.
three,
Three. That's been noted by-
disposed of, directing the third respondent to
Assistant engineer, my lord, who issued the notice.
take the proceeding under Section 10 of the Act of 1964 to its logical conclusion, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, in accordance with law. Within to its logical conclusions, within 1 month.
1 month.
My lord, your
No,
lordship
within-
pass the order, page 27, my lord, give the time of 3 months.
That at
Your
that
lordship
time,
order.
3
At
months.
that time, demarcation was not
Then
done.
one
so
has
it was
been
3 months.
over.
Very well, let it be 2 months.
Very-
ওখানে ঢুকিয়ে দিন, proceeding to its logical conclusion. Within 2 months from the date of communication of this order.
আমি communicate করবো।
ঠিক আছে।
Disposed of.
Because my lord, it is now.
Whistleblower.
It was pursuant to his application that
Yes.
it was done.
I was the whistleblower.
Next.
Number 8.
Is also, my lord, the construction over the PWD land in front of my house, my lord, by the private respondent 8 to 9, my lord. My lord, kindly come to page
This is
53.
under the 62 Act.
Yes, ma'am. Page 53, my lord. Kindly come to
Is
the.
it PWD road or
Yes,
government land?
PWD road.
Let the representation.
PWD land. PWD land.
This is appearing for the private respondents.
My instruction is that, my lord, a large portion of, my lord, the petitioner's land has been, my lord, I am occupying there, I am staying there. And a portion of, my lord, PWD land, my lord, is also, my lord, occupying. My lord, taking shelter of this proceeding, my lord, he is just trying to evict me. Your lordship kindly makes an observation. If anything is found, any position is found in respect of petitioner's riot land, my lord, that may not be included in this proceeding, because, my lord, that should be dealt with in a suit, my lord.
Sir, the authority will first
Where
demarcate.
is your representation?
Page 50.
Page 53, my lord. Page 53.
The prayer is with regard to the PWD land only.
Yes, let them confine to that, my lord, and I don't have any problem.
Yes, the representation will be considered. That's all.
The
Only one thing, my lord.
No private land is included in
Yes,
the
yes, my lord,
representation.
that observation.
Let the demarcation be made by the, my lord, under the proceeding. and-
Yes, yes.
No private land may be, my lord, included in.
That
this
is not included at all in the
My lord,
representation.
my lord, my submission is that, my lord, I am in a part of the private land and taking shelter of this, my lord, they have managed everything. My lord, that protection, my lord, so for the private land is concerned, my lord, given in this, my lord, proceeding. That may
That
not
will
be.
come under the, my lord,
My lord,
inspection by the
obviously they will, my lord, determine.
ALR.
The petitioner alleges unauthorized construction made by the private respondents on PWD land. PWD road. Paragraph, the petitioner submitted a representation in this regard before the concerned authority on 9th November 2020, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the private respondents that the private respondents have been occupying a portion of the petitioner's land besides a portion of the PWD road. Stop. Learned Counsel submits that the present writ petition should be confined to the portion of the PWD road occupied by the private respondents and the petitioner may not be allowed to evict the private respondents from his private land in the garb of the writ petition. Paragraph, learned counsel for the state respondents submits that the fifth respondent be directed to consider the representation in accordance with law.
Policy.
প্রথমে তো লিখছে কৃষ্ণনগর করিমপুর স্টেট হাইওয়ে তো
But that's something case of policy high mala in the Krishnanagar subdivision, because they have within a letter that the address is changed, madam. Madam, kindly allow me to correct.
It will be Krishnanagar subdivision. Yes. একদম শুরুতে
The policy higher subdivision, Krishnanagar subdivision.
একদম শুরুতে on prayer of the petitioner. On prayer of the petitioner, liberty is granted to correct the nomenclature of the fifth respondent in the cause title of the writ petition by incorporating Krishnanagar subdivision in place and stead of Plassey Highway subdivision. Paragraph, the cause title be amended accordingly. Last lines. In view of the above, the writ petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Stop. It is pertinent to mention here that the representation submitted by the petitioner is confined to the PWD road allegedly occupied by the private respondents and does not include the private land of the petitioner.
But it will be considered by the respondent number 5,
5. Assistant engineer.
not the SDO, not the SDO.
This is a PWD road. This is under the 64 Act.
Yes.
If it is 62 Act, it's the SDO. The public premises unauthorized occupation, that's the SDO. Disposed of. Yes, next.
কত বল
Or within mother.
কতদিন বলবো
Number 9. This is my application.
Yes.
A part of my land had been acquired by the NHAI authorities,
Who
my
is
lord.
appearing for the respondents? Mr. Siddiqui is appearing. Where is it?
Mr. Siddiqui is for the state. Is the NHAI, my lord? My learned friend represents the NHAI.
Mr. Siddiqui also should be present.
My lord, his presence is required, my lord. My lord, this is my report, my lord.
This is the report we were all awaiting.
Have you received a copy?
No, my lord, just
we
now, my
received
lord, I
it just
received this copy, my lord.
There's another stretch, my lord, if your lordship kindly
Has
comes.
the joint field inspection be?
Yes,
been-
this
has
is the
been
report
conducted,
pursuant to
my
the
lord?
joint inspection. Now, we say that a portion of the land has already been acquired. That's the one to your lordship's left at page 12. Kindly come to page 12. It is our contention in the writ petition that a portion of the land, my lord, has been acquired already. And while making the constructions or while making the subject work, the authority has now encroached into another portion belonging to the petitioners, not falling within the pale of the acquisition. So that was my grievance, that the authority should take into account that part also. And if they have acquired, if they have trespassed into my land for the purpose of working on it, they should acquire it. That's my lord, my limited prayer in the writ petition. And my lord, the authorities
Government
said,
should be there actually. Mr.
Mr.
Siddique's
Siddiqui,
presence
my
is
lord,
there.
my lord, where your lordship may recall, this is a case in which the NHAI was involved. Mr. Siddiqui, appearing on the earlier occasion, had also made it clear, my lord, that his presence is only for the purpose of form.
No,
Just
my lord,
because I made the
his
state of
presence
West
is
Bengal.
required, my lord, because he's
I
been
will not
appointed
stand in the
under the
way.
National Highways
I
Act,
am
my
not
lord, because
standing
he's
in the
doing
way.
his functions
My
independently.
lord, then kindly let Mr. Siddiqui appear at 2 p.m. my lord. We are putting him on
Not at
notice.
PM, I'll fix a date, come back. Please inform me.
I'll inform.
Who is appearing for the Union of India? Mr. Obonendra Chakraborty was appearing
Appearing at the
for the Union of India.
Amorendra Chakraborty. When the order was made on 2nd March 2023, my lord, NHAI and the state were represented. NHAI,
19th April 2023 was the last order. All of them were there. So please inform them the adjourned date.
let it come up, my lord, within a short time, my lord.
It will.
It's been awaited from
Report
April,
in
my lord.
the form of an affidavit submitted on behalf of the National Highways Authority of India is taken on record. Paragraph none appears for the state respondents as well as for the Union of India. Paragraph let the matter appear under the same heading on 20th June. 20th June. Paragraph the petitioner is directed to serve notice upon the state respondents and the Union of India, intimating the adjourned date. Please do that.
Kindly also
otherwise we
permit
cannot
us,
pick up the
Lord, kindly also permit us when we serve the notice to circulate copies of this report also, because then they can come ready, my lord. Otherwise, they've already given me a copy. May I just circulate this or
Lord, I will submit, my lord.
kindly direct them to circulate in the meantime so that my lord, they can come ready.
Yes, my lord, I will.
Why will the petitioner take responsibility?
I will.
Yes. No, no difficulty.
Next.
Number 10. My lordship.
Yes.
Not appearing for the state respondent.
I beg to appear on behalf of the private respondent, my lordship.
Who is appearing for the petitioner?
Which one?
There is no private respondent.
My lord, I am for the petitioner.
Yes.
Is respondent number 13 is a
Yes,
private?
please, place your case.
There are no private.
There is no private respondent, my lord. They have made something wrong. This is the fourth.
There is no private respondent.
Our is Sudarani Mondo. I'm sorry, my lord, this is the affidavit of service.
Please place your case. What is the matter about?
My lord, this is a matter of illegal encroachment beside the State Highway 1, which is called Chaktabonga Road. 15 to 20 illegal encroachers are encroached the government land, which is in front of my land. I have, along with my other co-shares, 21 acres of land just beside the State Highway 1. And in between the Mittal Road and my land, there is a strip of vacant government land, which is actually used by the pedestrian as footpath. That land has been illegally encroached by the occupants. My lord, this is the matter. This is, my lord, our second writ petition. First writ petition was disposed of by your lordship, directing the state authority, managing director, West Bengal Development, Highway Development Corporation, to dispose our representation within 1 month. My lord, kindly seize their order passed by the managing director in page number 30, which is very suspicious and strange. My lord, this order dated 7/11/2022 from the top of the para 5. My lord, they have admitted that the illegal encroachers are there. My lord, he further stated that the occupants on the government land were present for the last 15 years and running smooth.
Lordship, can you see paragraph number 2? May I repeat that?
You have only removed the encroachment in the working zone. What about the remaining part of the road?
That has not been, I do not have that instruction, but we can do that. not the land encroaches, this next
This
page.
report
not
is
your lordship, kindly-
meaningless.
No, your lordship, kindly see, the next page.
I've seen the report, yes.
Next page that
It's absolutely a
paragraph 10,
meaningless report.
paragraph 10, in this particular case, the land does not belong to the petitioner, so they cannot claim for vacating the encroachment for the lands which do not belong to them. This is
So there
my-
is nothing called the West Bengal Highways Act at all.
No,
This is an absolutely bogus and meaningless report. Please take
My
it
lord.
back.
My lord.
You say that there is encroachment and you
There
don't
are,
remove.
it has been.
And this is
admitted by the
definitely
Department of-
for
I've seen it,
extraneous
but I've-
reasons.
Similar footing, Lord, your lordship also passed an order, I remember.
Affidavit of service. Where are they? The petitioner complains illegal encroachment. This should be a contempt matter actually. On PWD road, PWD land.
My lord,
By
it is not it is not under the purview of PWD. It is the West Bengal Highway Development Corporation.
And the instruction also has been passed by the respective authority of the West Bengal.
Managing Director, West Bengal Highway Development Corporation has passed the order.
It has been passed by the project director and assistant project director. My instruction.
Petitioner sentenced, the petitioner complains in illegal encroachment of the West Bengal Highway Development Corporation Limited. The land is under the
Is under the purview of this corporation.
illegal encroachment of
You have made that
land,
verdict.
My lord, the respondent number 2 herein.
of land under the West Bengal Highways Development Corporation Limited. Stop. Pursuant to an earlier petition filed by the petitioner, being WPA 3430 of 2021, this court, by an order passed on 2nd September 2021, directed the concerned authority to dispose of the application filed by the petitioner within a stipulated time frame.
My lord,
Upon affording opportunity of hearing to the interested parties. Paragraph. Pursuant to the said order, the managing director, West Bengal Highways Development Corporation Limited dealt with the matter and by an order passed on 7th November 2022, recorded that there are occupants on government land for the past 15 years. And there is no reason to remove the said occupants till the land is required by the government. Yes, you wanted to add something?
my lord, the first writ petition order was passed on 29/2021 and it was modified on 27th September 2022. The first was directed to the PWD. Then the PWD said that this is not their portion. Then the order was modified and directed upon the managing director, my lord.
Page 28.
Page 28, my lord. The modified order.
By an order passed on. Add couldn't and modified on 27th September 2022.
Yes, my lord.
Paragraph. It is the first order was on 2nd September 2021 and the modification was 27th September 2022.
2022, my lord.
First order 2nd September 2021.
That is at page 25, your lordship.
No. By an order passed on 2nd 7th November হচ্ছে এগুলোর order, highways development এর order, শুরু থেকে আরো আগে ছিল। তার আগে, হ্যাঁ ওইখানে হবেই না, তার আগে পার্সেন্ট থেকে সেটা আমার আগে বলুন, হ্যাঁ ওখানটা বলুন, তার আগে (2021) and modified on 27th September 2022. Director. 7th November 2022. ওখানে modification না, pursuant to the said order. Last sentence to one. Paragraph. It is strange to note that though the concerned authority found illegal encroachment on government land, comma, he refrained from removing such encroachment for reasons best known to him, comma, which may in all probability be extraneous in nature. Stop. Such a decision is not only ridiculous, but is also unknown to law. Paragraph. In view of the above, this court is inclined to hold that since encroachment upon government land has been found by the authority, comma, the concerned authority being the
Managing Director.
second respondent hearing, comma, is directed to take necessary steps for removal of such encroachment within 1 month from the date of communication of this order.
A little more time if you.
No, my lord, there is
Upon
no
affording-
need.
you have already got time and you have not utilized it.
My lord, obliged, my lord.
Upon affording reasonable opportunity of hearing to all the
Because the
interested
Panchayat
persons,
election is ahead.
including the
So why
petitioner,
we will suffer?
including the petitioner, comma, in accordance with law.
Not my instruction, your lordship will kindly keep it in the record. So it will be on evident that I have submitted my, your lordship kindly appreciate my petty comment.
Instructions, yes, written instructions submitted on behalf of the state respondents is taken on record.
Lord, since the election of the Panchayat, Lord, is ahead, your lordship kindly, it is my humble prayer before my lord, instead of 1 month, this is my respectful submission
Because you
before my
have
lord.
taken extraneous, you have made, you have.
Lord, I do understand, I
My lord.
appreciate, I have
This
seen
is
the.
not
language,
grateful,
taste
grateful,
and
my
tenor-
lord.
Taste and tenor of the.
We are very much
language,
obliged and grateful, my lord.
taste and
Grateful,
tenor
my
of
lord.
the Instructions I have gone through also. I have seen your lordship's order, I have seen the order of.
My lord, this is actually act is very suspicious what they are doing.
Warn your authority that they'll face contempt if this is not done.
My lord,
My
my lord, grateful to you, my lord.
Not only the thing, my respectful submission instead of 1 month since the
I will not
Panchayat
give you
election.
a day more.
My lord, the West Bengal Highways Act Section 6, powers and duties of highways authority is clearly states, my lord.
Next one.
My lord, my lord.
And I'm sorry that I had to appear in this matter.
Oh.
Lordship,
A wrong file has arrived, let it be not.
grateful, not today. Lordship, matter can be fixed day after tomorrow. Otherwise, I'll be.
File is not there, I cannot. No order can be passed actually. But if you have some difficulty, mention it. I'll, yes.
Number
Self-
12.
My lordship. My lord, I'm for the petitioner. My lord, I'm paying password, short password.
Passable is not possible.
My lord, then my lord, kindly make it not today only.
Not
my lord.
possible.
My lord, kindly, my lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 22nd June. Next.
Report. Number 13. My second. 22nd.
Yes, 13.
Applications for extension of the mining fees. That is apart from the COVID, is there? There are another reasons that the petitioner was not allowed to carry on activities almost 2 years. This was registered on December 2017 and it is expired already expired on the 14th December 2022. So I have made several representations to that paper that has not been considered. So far as my contention, the petitioner was not allowed to enter, I made the amendments in paragraph 6 and 7 in my writ petition. And supporting to that, I have also annexed made some documents and representation.
Where is your representation? Where is your representation?
18 January, 5th July.
Page 77. Page 77. Onwards. To my last representation.
এরপরও আছে 5th জুলাই পরেরটা।
These are not identical representation.
Identical matter. Lots of
Before several authorities.
Yes.
Before several authorities. That lots of time become page 48 and 49. In respect of my submission that the petition was not allowed to carry on the activities, I have made application before the BLRO that the villagers was not allowed to enter the mining to carry on the mining activities. That may be considered at the time of legal consideration.
Page 48.
48, 49 and 50. So my submission is that at the time of consideration.
49 is a query made by the police.
It's the report.
So you can submit these documents before the authority. Have you submitted them with your representation?
I have submitted. My last submitted on page 77. I am saying that here, this representation be kindly considered at the time of consideration. This representation also be considered that at the time of carry on the activities, the petition was not allowed. My prayer is very simple.
তুই সেটা পেয়ারে করেছিস? দেখি
Where is it stated that you are not allowed? It's only a complaint made by you.
Kindly come to page.
So file all the relevant
Government's
documents.
statement is there that the local villagers were not allowed the petitioner to enter into the mining leasehold area. That is.
Place all the relevant documents before the authority,
the-
they'll consider. Yes.
Then I will place.
Let the authority consider, Mr. Shah.
নতুন করে করবে না ওইগুলোই consider হবে।
Because you may be having other documents also.
But if this is document, then kindly give liberty to make a fresh representation.
Yes, সেটাই তো
Complete
বলছি।
representation along with all
Along
these
with ওই পুলিশের রিপোর্ট ফিপোর্ট যা
And,
আছে সব নিয়ে করো।
Being the highest bidder, being the highest bidder in the e-auction floated by the respondents on 4th July 2017, the petitioner was granted long-term mining lease for a period of 5 years. Deed of lease dated 15th December 2017, which expired on 14th December 2022. Stop. The petitioner was unable to carry on mining operation in the said block due to resistance offered by the local villagers and anti-socials, and also advent of the COVID-19 pandemic. Stop. The petitioner seeks to submit a comprehensive representation along with relevant documents before the concerned authority for extension of the period of lease and prays for a direction upon the authority to consider the representation at the earliest. Paragraph it is submitted on behalf of the respondents that the fourth respondent
But the force majeure clause kindly be mentioned.
Yes,
The force majeure clause I have entered to invoke
page.
is page 40. Page 40.
Sentence to শেষ করুন। The fourth respondent be directed to consider the representation in accordance with law. ওখানে যেটা বললাম না, petitioner seeks to submit a representation per article 11. The petitioner takes this court to clause 5 of of part, this should be 9 or 8, part Roman 9 of the deed of lease, which demonstrates that failure of the lessee to fulfill any of the terms and conditions of the lease due to force majeure shall not give the state government any claim against the lessee, and the period of delay in fulfillment of the terms and conditions shall be added to the period fixed by the lease. Therefore, the petitioner seeks to submit a representation. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive, I'm not audible, to submit a comprehensive representation before the fourth respondent within 7 days.
Within 15 days.
Within 15 days from date. Stop. The fourth respondent is directed to consider and dispose of the representation submitted by the petitioner within 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Grateful.
Disposed of. Next.
No, 14.
This is second round of litigation.
Who is appearing for the respondents?
The state has been served. Page 89, your lordship's own order.
State is, the Pradhan is also there.
They are all, everyone has been served, delivery confirmed. And my grievance is that my land that is being used for pump operation under PHE without paying any compensation or nothing to me. I approach this honorable court. Your lordship was pleased to.
May I request Mr. Dey to appear? State has been served. Please serve a copy.
Yes, here and now I am serving a copy. Page 89, your lordship's own order. Whereby, my lord, we were granted liberty to make a comprehensive
Where is
representation.
the service upon the private respondent?
But deliver confirm. It's not a private respondent under them.
Seventh respondent.
Kindly have a look at the fast track report.
Very well.
Page 89, your lordship's own order, whereby my liberty was granted to us to make a comprehensive representation before the authority. Pursuant to that, page 92, our comprehensive representation. Now the authority, my lord, they considered this and rejected. The principal secretary, PHE department, page 96. Is 95 onwards, 96 years, 96 onwards.
What is the ground of rejection?
His ground is that in 1992, my father consented to construct such pump operation house or others, and there is no scheme of the government to pay compensation to anybody. But our case is that this is a purchased land. We didn't inherit it from our father. Both the brothers, we purchased it on our own name. Now there they constructed it with they promised us to provide something that has not been complied with. My simple case would be before Lordship. Now government neither can take the plea of adverse position, nor they can say about the limitation cause. It's a continuing cause of action. Moreover, they have no authority to take my land without making payment. I am ready to transfer. Purchase it, no problem, market value purchase it, or pay compensation to us. In other cases, in PHE matter also, my lord, pursuant to this court's order, they are paying the compensation. In one of my case, my lord, I got it. Here they have taken, my lord, a beautiful plea.
Mr. Dev, will you be in a position to make your submission today? I think he needs to take instructions on this.
We must pay the amount, but we must see this, my lord,
Please take instructions and come back.
the form of it, my lord.
Yes.
He needs to take instructions.
Yes.
Affidavit of service. None appears for the respondents despite service. Stated, Mr. Dev, copy service at direction. Paragraph. It is submitted on behalf of the petitioners that pursuant to an order passed by this court on 22nd November 2022 in WPA 5503 of 2022, the petitioners submitted a representation before the concerned authority for payment of adequate compensation for utilization of their land by the authority for setting up a pump house therein. Stop it. Paragraph. Learned Counsel under the Public Health Engineering Department. Paragraph. Learned Counsel for the state respondents seeks to take instructions in this matter. Paragraph. Let the matter appear under the same heading on 4th July. Sufficient.
Number 15.
I for the petition amendment.
Yes.
Respondent number 3, 4 and 5.
Who is appearing for the petition?
For the petition.
The state, Mr. Dev.
This is regarding, my lord, allotment of plot by the HITCO. By the
No 5, Mr. Majumdar, 3 and 4.
3, 4 and 5.
There is no 5.
Oh, the 3 and 4. I'm sorry. Now let me have it.
HITCO.
2, 3 and 4. I'm so sorry.
3 and 4. Very well.
So sorry. This is regarding allotment of plot by way of lottery, my lord, to by the HITCO, my lord, to cooperatives. My lord, the petitioners before lordship are members of such a cooperative who applied in terms of their notification of, issued in 2021. Thereafter, my lord, we deposited our the dues, the money which is asked, which we have been asked to deposit. My lord, the plot was also allotted in our favor. The allotment of plot number 11B, my lord, was allotted to the petitioner. That also will find at page 57. Thereafter, my lord, the handing over was not taking place. My lord, we made a representation, and thereafter we were told, my lord, my representation is page 60, my lord. Kindly have a look at page 60. We wanted to know the reason why this allotment was not taking place in our favor.
the handing over. My lord, at page 62, my lord, that is the reply we received. We say that we don't come within the, we don't satisfy the conditions. My lord, না 62 ঠিক আছে
62 ঠিক আছে হ্যাঁ ঠিক আছে থ্যাংক ইউ
My lord, the dispute here is, my lord, the petitioners, my lord, who formed the cooperative were all employees or government employees, but central government undertakings. The notification which was issued in 2021 does not differentiate between central government undertaking, employees of central government undertaking, and state government undertaking. Well, the subsequent notification which has been issued in 2023, now it has been specified that government employees will necessarily mean employees of state government undertakings. Well, we applied being understanding that this notification covers both central government undertakings and state government undertakings. My lord will kindly see the clauses at page 32. That is the clause of the 2021 notification according to which we applied. My lord, kindly
Page?
32.
So they now say that you are not eligible.
Yes, my lord. Type 1, my lord, we applied in type 1. Housing cooperatives formed exclusively by government employees, including police. Type 2, housing cooperatives formed by persons not belonging to type 1. The term government employees, including police, will be defined as follows. All West Bengal government employees, including police, the teaching and non-teaching employees of government of West Bengal, aided educational institutions, employees of statutory bodies in West Bengal. But we applied in this. Statutory bodies in West Bengal. It does not say statutory bodies of West Bengal. But a central government undertaking having office in West Bengal becomes statutory body in West Bengal. My lord, the exclusion clause. Now, kindly comes to page 33, which is the exclusion clause. But it says the first line, however, the term government employees, including police, shall not include the following categories. Government employees appointed on contract, government employees not in whole-time employment, government employees paid otherwise than on monthly basis, including those paid at piece rates. Well, this does not exclude a public sector undertaking or an central government undertaking in West Bengal. Well, these clauses have now in 2023, the new notification has undergone a change. My lord, we find that at pages 78.
Yes.
Page 78 again gives me type 1 and type 2 defines in the middle of the page. It says type 1, housing cooperatives formed exclusively by West Bengal government, West Bengal state government employees, including police. Type 2, housing cooperatives formed by persons not belonging to type 1. The term West Bengal state government employees, including police, will be defined as follows. All West Bengal state government employees, including police, the teaching and non-teaching employees of government of West Bengal aided education institutions, employees of statutory bodies of government of West Bengal. Now they have specified that it has to be statutory bodies of government of West Bengal, but earlier it was not so. Well, my contention in this repetition is that when I'm not specifically disqualified in your notification, and this subsequent notification further explains that the earlier notification actually covered me, because otherwise they would not have issued this modified notification in 2023.
Has this been given retrospective effect?
No, this is from 2023. This is a new advertisement. the express intention to cover only state government statutory bodies in the further notification of 2020, subsequent notification of 2023 itself makes it clear that that was not the intention earlier. My lord, I am challenging the cancellation, my lord. My earnest money has been returned to me. That they have done. They have not forfeited it. They have returned to my bank account. I have received that without prejudice to my rights. But I am challenging the cancellation. This is only the sole ground that we are not coming within the notification because we belong to statutory body, not within West Bengal. But this is the short point involved in the matter. My lord.
The HITCO should be the answering respondent, yes.
Yes, my lord. May I just take your lordship to first some facts which, my lord, I believe ought to have been disclosed in the writ petition. My lord, your lordship kindly take page 60 of the writ petition first.
Yes.
60. But this is the show cause notice which was issued upon the petitioner.
Yes.
My lord has got that. 62 is their reply. Now, my lord, on 18 January, my lord, the refund was made by way of this electronic bank transfer on January 6, 2023. My lord, a reasoned decision was communicated to the petitioner on 18 January 2023, which perhaps is missing in the writ petition.
It's not part of the writ petition.
My lord, I tell your lordship, my lord, I have the copy of this 18 January communication.
Has the petitioner received the said
My
communication?
lord, that instruction I have to take because, my lord, I am not in a position to comment on it because I will not be making any submission.
But the petitioner doesn't seem to be aware. That's why.
My lord,
But I have not been supplied with this. I have to take instruction.
My lord,
18 January.
18 January. Second point, my lord. My lord, bereft of all this, my lord, if your lordship kindly takes the clause, well, I would beseech your lordship kindly to read the clause as a whole and apply the principle of nocere socias. All the words employees, I mean the statutory bodies in West Bengal must take color from the accompanying items. And if we look at the accompanying items, your lordship will find without any doubt, subject to lordship's kind consideration, that this would mean and only mean the employees of either directly who are holding civil posts in the under the government of West Bengal or statutory bodies governed by government of West Bengal, any state enactment, or my lord, lordship will kindly take. This is very important. Kindly take page 32 for once.
Yes.
The term government employees include being police will be defined as follows. All West Bengal government employees including police. So these are my civil posts. Teaching and non-teaching employees of government of West Bengal aided educational institutions. Aided institutions. Employees of statutory bodies in West Bengal. Emphasis is being supplied to in contradistinction to of government of West Bengal used in the latest advertisement. Kindly see the following item. The following item is government of West Bengal undertakings. The next item, panchayats including panchayat karmi within the state of West Bengal. Thereafter, municipal corporation, municipal local bodies within the state of West Bengal. West Bengal state government pensioner, family pensioner. Well, if you look at all these items, my lord, if these statutory bodies in West Bengal must take color from all the accompanying items, and it would only mean statutory bodies which are created by any enactment made by the state legislature. And in any event, my lord, we have disclosed, my lord, we have given a decision. My lord, that decision was, but whether it was communicated to him or not, my lord, I will not make that comment.
That instruction is necessary because then the writ petition becomes redundant. Actually, he has to challenge the decision.
He has to challenge. My lord, so may I come back after
Please do
taking
that.
instruction? My learned friend may also take instruction.
Please show me that it has been communicated.
My lord, but if it is communicated, I will tell your lordship. If it is not communicated, your lordship knows me. I will tell you.
Because the petitioner has to take necessary steps on that.
Yes. My lord, kindly give us some time and we come back next week. Subject to
When do you want to come back?
কবে আসবি বল? Next week যে কোনো দিন? Monday টা করিস। Any day apart from Monday and Tuesday, my lord. Wednesday, Thursday, whichever date.
21st June?
Yes, great.
I've heard learned counsels for the parties. the no, every services. Show cause notice issued upon the petitioners on 30th August 2022, the notice,
My lord, the show cause notice.
the show cause
Yes,
notice.
my lord, it is 2022.
It's
I'm-
not very legible
My
actually.
lord, I tell you, lordship, is August 30, 2022.
2022 is assailed in the writ petition. Paragraph, it is submitted on behalf of respondent numbers 2, 3, and 4, that pursuant to a reply given by the petitioners to the said notice, comma, a reasoned order has been passed by the concerned authority on
My lord, January 18, 2023.
January 18, 2023. 2023. Learned counsel seeks to take instructions as to whether such order has been communicated to the petitioners. Paragraph, let the matter appear under the same heading on 21st June.
Grateful, my lord.
Number 16.
16, may I please, your lordship, I am for the petitioner. My lord, what happened
For
in
the
this
state
matter?
authorities led by Mr. Mitro.
My lord, in this matter, the private respondents are forcefully and
Who is
illegally.
appealing for the private respondents?
My lord, I have served all the private respondent and the track report shows they have received.
They have received?
Yes. My lord,
Yes.
my lord, the private respondent forcefully encroaching the public road in front of my house, constructed the illegal construction and obstructing me to ingress and egress from my property. My lord, I made a complaint before the executive engineer, PWD, as well as other authorities. They have not taken any steps and they are going, the private respondent are continuing the construction works. That's
Where is
my
your representation?
my lord, my representation is page, it starts from page 27.
So let this representation be considered by the authority?
My lord,
Yes.
may I submit one thing? My lord, assistant engineer, my lord, has already, my lord, sent a letter to the, my lord, concerned block
BLLR.
BLNL for demarcation of the, my lord, vested lands and the other, who are the actual occupants of the unauthorized occupants. My lord, that process is going on.
So let the process be completed.
Yes, yes,
My lord, my
yes,
lord,
yes.
my lord, that will be better.
2 months?
2 months.
And the necessary, if they found that the unauthorized construction is there by enclosures, by the private respondent,
Obviously do that.
That
then
will,
my lord,
in
kindly
accordance with
indicate,
law.
otherwise they will delay the process.
Affidavit of service, paragraph none.
Yeah,
It will be a time bound process.
Yes.
None appears for the private
May I pray
respondents
for
despite
you
service.
to, my lord, another matter is.
It is contended on behalf of the petitioner that the private respondents have raised illegal construction by encroaching upon a portion of the PWD road adjoining his property, comma, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 29th March 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents, the state respondents, that the fifth respondent
My lord.
be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. In view of the above, it is submitted on behalf of the state respondents that pursuant to the representation submitted by the petitioner, comma, the assistant engineer, Kharagpur Highway Division, has issued a letter to the Block Land and Land Reforms Officer, to the concerned Block Land and Land Reforms Officer for demarcation of the plot in question, and such demarcation work is in progress. But Learned Council further submits that the fifth respondent be directed to disposed of
Grateful.
within 2 months.
Mal.
And now 17.
Lord, I appeal for the West Bengal Mineral Development Association with the instruction.
I
Petitioner?
got the petition.
Yes. State?
No, Lord, this is a different matter.
Who is appearing for the state?
And I am appealing for the same with Osmingam.
For the state? Yes.
The matter has been mentioned, my lord, without any notice top of the list. The matter was appeared. Take mention without notice.
No.
Each and every time, and it is very bad.
This was mentioned?
Not to mention.
Mentioned,
Without
but without
notice?
any.
Notice the notice has been served. This is a new motion. 23.
New motion, no.
23rd
Matter was
matter.
appearing. March to March, copy was served.
Are you
Our
ready?
Honorable Lordship,
Are you ready today?
Yes. Sometimes on the non-issues.
Yes.
Lord, you kindly come. Page 25, the lease deed. My lord, the lease deed was. The lease deed was registered on 27 June 2018.
26 June 2018.
26 June is executed, but registered on 27 June. Not to kindly write the stamp 27 June. Not to kindly come thereafter. The page 74. Page 74.
Report the details.
Page 74. The
I know.
possession.
It is the report, my lord. There is no provision.
Page 74.
Yes.
Okay. In pursuance of deed number such and such executed between the district magistrate on behalf of the government government and success bidder of the sand block in the such and such as per direction of the additional district magistrate and district land reform officer, member secretary, district committee, bidding committee, diagram communicated by data such and such dated 14 August 2018. The possession in respect of plot number such and such is hereby handed over to the petitioner on this very day, that is on 12 April 2019. Which is the contention is that since the lease was executed on 27 June 18, and the possession was handed over on after lapse of 9 months. Then, my lord, kindly come. I made an application. Page 76.
For extension?
Extension. Page 76. Wherein I have stated and prayed that since my physical possession was handed over on 12 April 2019, so lease period should be counted from then, and it is valid, should be valid up to 11 April 24. This is my representation.
Which is your representation?
Page 76. Page 76. Let's show us got. Page 76. Let's us got.
Page 76.
76.
Yes.
In view of the fact that we have acquired possession, this sand block, the validity of lease period should be counted from the date, and from not from the date of registration. Eligible advertisement, the lease should be considered valid up to 11 April 2024.
Yes. Yes.
In reply to that, Lordship, their reply, what they are saying. Page 77.
Yes.
After execution of the lease deed, you are intimated that the lease period is from such and such, but you have acquired possession on 12 April 19 at your convenience. There is no delay in the part of the authority in this regard. In respect to Lordship, I have further made an application. Page 78. Wherein I have stated, will you kindly come directly, paragraph 3.3. Your contention in your above mentioned letter that we have acquired possession as per own convenience is not relevant, we are no position to take sumoto possession of the plot and are totally dependent on the local BLRO, who only have the authority to demarcate and hand over possession of the plot to the lessee to start operations. Lordship, kindly come next paragraph. We had next paragraph we have mentioned we had neither any intention nor justified reasons to delay the start the operation, having paid in full bid amount for the lease period in advance. Lordship, there is no such word on my petitioner's fault. Petitioners paid the entire amount, and Lordship, kindly look at that the writ of possession, wherein they have clearly stated as per their order, DM order, the local BLRO is handing over the possession.
Yes.
But in this respect, Lordship, kindly have your Lordship's order. I may place. In this order, your Lordship has observed in another matters. In my matters, Lordship, kindly come directly in paragraph 3, page 3, in your Lordship's order. As laid down by the earlier judgment of this court, in terms of the lease ought to be commenced from the date of when delivery of possession of the leasehold and in question is handed over to the petitioner. As in the case in hand, the petitioner acquired possession of circumstance, the period of lease shall be counted from the date, said date, not from the date of execution of same. In the result, the period lease should be valid till circumstance. Lordship, your observation, I am placing this order, Lordship. So my prayer is that my lease should be valid till 11 April 2024.
Yes.
This is my submission. Lease should be ended on 11 April 2024.
Yes, state.
Malayologically, see the P7 page 77.
Page
77.
77.
This order we are in
Your Lordship, kindly the order under challenge, Lord. This is an applicable order. Your Lordship, kindly come to page 77. Page 77. The order impugned. The order has been passed by the additional district magistrate and district land office. It is an appealable order. You can prefer an appeal under section 51. Let him prefer an appeal. Page 71. Page 77. Your Lordship, kindly see P7. And your Lordship also look to the prayer. Prayer G.
This issue has already been decided, Lordship.
No, last case also you have said the same thing decided.
Not same thing.
Since it is an applicable order under the provision and there is no condition for extension of leaves as per rules
Even there
2016.
In reply to that, I have made a further reply.
Maybe
That has not replied.
you prefer an appeal under
Rule 51 is a bar.
Lordship,
Rule 51 is a bar.
Lordship, does the issue by issue over this cannot be decided by the divisional forum, appeal forum.
Yes.
The issue what I raised before Lordship, this has to be decided because of the similar circumstances. Your Lordship have decided.
This point was not raised before this court in the earlier occasion.
same issue in the my earlier matter also is raised.
This is in terms of the rules.
And also, my lord,
Because renewal clause from the date of possession or from the date of registration, this is the lease itself. The lease says date of registration. There may have been an earlier order, but then this point was not raised by the
Then Lordship,
respondents.
one thing I can pray before your Lordship, that if I go appellate forum, my lease is expiring on as per the registration on Lordship 26 June this month. It cannot be. So before deciding the appeal,
Over.
the status quo should be maintained.
No, my lord, I remain the
Or
objective.
not to any positive
My
action
lord,
in respect of.
the petitioner has claimed that he has received the position 9 months later. But she waited for 3.5 years to make this representation that there is a point of delay. Not on any early occasion, my lord.
He made the representation only when the deed was coming to the verge
Yes,
of
ma'am.
close.
He was waiting for the lease period to expire.
So it is within limitation. There is no bar.
Yes, my lord. He can go for appeal under section 51.
That is another issue.
Already it has been expired. This got expired. Even others know that there is, it is an appealable order under section 51. He can go and prefer an appeal.
Please prefer an appeal within 15 days.
Lordship 15 days.
It is valid
Be
till
decided on
26 June,
merits.
my lord.
But with the
And it
decision
is-
of the appeal, Lordship, the
25th June
no
is
positive
expiring
action
date.
should be taken.
There is no question of coercive action.
Lordship, they may,
Are your lease
If
the
the-
plot may be put in on auction.
I'll
No, no.
request the authority to deal with your appeal as expeditiously as possible.
Lordship, but in that defense, Lordship, can
Nothing.
you can protect? One thing is.
What is the
because-
protection? Your
If the
lease
matter
period
is not
getting
maintainable
expired.
before this court, how can the court protect? It's not maintainable at all. Affidavit of service. You are submitting a report, Mr. Ganguly? in
No,
this
he
matter?
has submitted, my learned junior friend has already.
Left side by your deputy.
A report submitted on behalf of the
Lord,
state
may I take
respondents
leave?
is taken on record.
ওইখান থেকে জেনে গিয়ে
The order passed by the
ওইখান থেকে জেনে গিয়ে একটু ভালো হয়েছে চলো।
Additional District Magistrate and District Land and Land Reforms Officer, Jhargram, on 13 December 2022, is assailed in the writ petition. Paragraph, the said order is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules, 2016. Paragraph, in view of the above, the writ petition being developed such and such is dismissed as not maintainable. Paragraph, however, the petitioner is at liberty to prefer a statutory appeal before the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers such appeal within 15 days from date, the statutory forum is requested to deal with the appeal on merits after condoning the delay in same sentence, after condoning the delay in filing the same. The authority is further requested to dispose of the appeal as expeditiously as the business of the authority may permit. Dispose of. And there shall however be no order as to costs or urgent certified website copy.
Report or report? Report.
Taken on record.
Please, order a copy, please.
Next matter.
Judgment copy. Yes.
Number 18.
My lord, Deputy Order of Service.
Respondents, you are for the petition.
First, I am for the petitioner.
Who is appearing for the respondents?
My lord, Mr. Ramchandra Guchai is the state respondent.
Has he appeared in this matter? No.
No, I have I have mentioning and served notice upon I have upon notice served. to
You
the-
know that he has been allotted this brief.
Yes, lordship.
Where is Mr. Guchai? I could have requested Mr. Day to appear in this matter. No one is appearing, Mr. Day. Please serve a copy to Mr. Day. Let him appear. Yes.
My lord,
make your submission, please.
matter regarding illegal encroachment. The private respondent constructed unauthorized construction over the PWD land and causing obstructed the ingress and egress of the petitioner's land. My lord, the petitioner filed the representation before the authorities. My lord, come to page at 29. My lord, kindly consider my representation. My lord, page 29. Assistant engineer, sixth respondent.
Let it be considered. Affidavit of service. Paragraph none appears for the respondents despite service. Mr. Dey, who is present in court, unusually regularized school service, copy service direction. Paragraph, the petitioners claim to be the recorded owners of the plot in question and complain petitioners and complain that the private respondent has raised illegal construction by encroaching upon a portion of the PWD land adjoining their property, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on 9th March 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the sixth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the sixth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, in accordance with law. Disposed of, which are
Grateful.
next.
Number 19.
20 minutes, I am for the petition.
Mr. Dey, for the state?
Yes, madam. My lord,
Objection.
if your lordship will see the first item, West Bengal Land Reform Act 19.
My lord, may I, my lord, state about the case, my lord. My lord, the problem, my lord, arose because, my lord, the private respondent, my lord, tried to change the nature and character of the land. My lord, my lord, it's a cultivable land, my lord. Now, my lord, the private respondent, my lord, what he did, my lord, was dug the land.
My lord, I am for the private respondent. But if your lordship can you take it up tomorrow?
There is a preliminary issue. Let me just hear.
All right. No, I am for the private respondent.
Yes.
State rule is
State.
My lord, the private.
But this is with regard to conversion of land.
This is land. It is land.
So-
Will go. That's
Not
why I was
conversion,
also-
my lord. What the private respondent
They are against
did was
that.
illegally, my lord, encroach the land. So the illegal, not encroach,
Then they
illegal,
sued.
my lord, illegally, my lord, converting the land from Bastu, my lord, to Pukur.
That is the subject matter of land.
My lord,
reform
so that
act.
when the saline water is seeping in, and what is happening is, my lord, the petitioner's land is just adjacent to the private respondent's land. The cultivable land is becoming non-cultivable. This is the difficulty.
Your primary prayer is against the conversion.
This is illegal conversion.
Prayer A.
Yes, yes.
So this court doesn't have jurisdiction. You are aware.
Comes under Land Reforms Tribunal Act.
My lord, but the BLR have approached the BLR, my lord. Your lordship is of the opinion that I should, my lord, approach.
Specified act.
That is the remedy.
Land
My lord,
Reforms Act.
conversion, if it is allowed by the BLRO after that, my lord. But the difficulty is, my lord, this is not conversion at all.
West
This is-
Bengal Land
this is-
Reform
this
Act.
is-
How
this is-
you
What is the provision for conversion? Under which act?
Land Reforms Act. But my lord, if the statutory provision is followed, only then, my lord.
Even if it
Nothing
is
has
not
been-
followed,
Nothing has been
even
followed.
if it is not followed, then also the Land Reforms Act comes
Yes.
into play.
Even if his record of rights is not recorded, then it's also.
Withdraw and approach the appropriate forum, or I have to dismiss it.
My lord, kindly takes it
Now
up.
it is your
My lord,
choice.
kindly, my lord, does it tomorrow. Either, my lord, I'll just tell my client.
No,
my
no,
lord,
that if preliminary point, your lordship can decide it.
My lord,
I'll send it.
my lord,
I'll-
just
use
now, my lord,
unnecessary
my
wasting-
learned friend,
No,
my
that is
lord.
on merit. Since it is.
Without wasting further time, approach the authority. I'll grant you liberty.
Liberty নিয়ে না
My lord, kindly does not do it in my lord on my on my presence, my lord. Kindly, Mr. Roy, my lord.
I have expressed my mind, so things will not change, sir, even tomorrow also.
No, certainly, my lord. My lord, Mr. Roy must be.
Because
my
I've
lord.
already expressed my mind and now you cannot ask for an adjournment. The primary prayer of the petitioner is against an allegedly illegal conversion of land made by the private respondent. Stop. The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph. The petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance. Paragraph. In view of the above, the writ petition being WP such and such is dismissed for non-prosecution. Liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance.
Fine.
There shall, however, be no arrest costs, urgency referred to website.
It's not fine. It's not fine.
You cannot
That's fine.
further develop on this.
Fine. Show me. Fine. Respondent.
Next.
Number 20.
My lord, this is my application, my lord. My lord, we have come up in a very strange situation. The petitioner before your lordship, my lord.
What about the respondents? Who is
My lord, we have prayed for my lord leave under. Oh, diye diyecho tumi? My lord, we have served, my lord. And my lord, my learned senior friend is appearing, so I am in safe hands. My lord, the only thing, my lord, which I want to project before your lordship is, my lord, kindly turns to page 22. My lord, this is my lord, an acquisition of land which was done, my lord, under the West Bengal Land Development and Planning Act, my lord, for the rehabilitation of certain people who had migrated. My lord, this is the classification, the DAG and all. My lord, since ages, my lord, initially, my lord, the grandfather. My lord, the grandfather of the petitioner, my lord, was the one. My lord, kindly comes to page 17, my lord, in whose name it is written as owner. My lord, they are in occupation.
17.
17, my lord. P1.
Yes.
So, my lord, I am basically the grandson. Now, suddenly, my lord, few people are trying to encroach on our land. And my lord, the dispute which they are trying to project, my lord, is, my lord, that there are certain lands which are not acquired. My lord, this is how, my lord, they are trying to take over. My lord, only limited thing which I am wanting at this stage, my lord, before, my lord, my learned friend comes up with other affidavits and all, my lord, let there be.
Petitioner.
My lord, I am being led by Mr. Bhattacharya.
Let her do this for her. No problem.
No, my lord.
She's
My lord, we always have that privilege of appearing with seniors. And when we get that privilege, we really.
Admitted position, we were the refugees, my lord, sent back from the Bangladesh in 1950 and last many years, my lord, we are staying in an area, my lord, acquired for the purpose of settlement of refugee by the RR department. Our position is that, my lord, we are KMC has recorded our ownership or position, not ownership. I'm sorry, but I mean rectified. It is the only the Department of RR, my lord, to issue us a patta, formal patta. Until it is given, the promoters are falling on us that we should leave it, we should take it over, position will be taken over. But we are absolutely in a soup. We are paying tax in one hand to the corporation and other hand, my lord, the RR department is not giving me the patta. I am making a prayer, my lord, let them expeditiously issue me a patta, my lord. And till then, let there be a status quo with regard to my position.
My lord, for that is, my lord, he must file an application before the authority.
No question of application. We are recorded refugees.
Right of that, you must file an application before the authority.
Now, what is your answer? What is your stand? Kindly, my lord, state authority state authority must come forward with the stand that why they have not issued the patta.
Consider. Till such consideration, my lord, status will maintain.
As your lordship, I am grateful to your lordship. But I shall make it.
So will you file an application for issuance of patta?
Yes. I have already previously filed application. Now again, a formal application will be filed. My lord, kindly fix a time limit within which they will be considering until then status will be maintained.
Respondent number 4.
Grateful.
Very.
Deputy controller.
তুই জানো না, তুমি তো সবাই গাইড করেছে, চুপ করো।
Affidavit of service.
বাবা দোষ ভাই দোষ করবে, দাও
The petitioners
চুপ করো। কাকে যে করবে অ্যাপ্লিকেশনটা? Respondent number 4.
have contended that the plot in question
অ্যাড্রেস আছে।
was allotted to them
দম।
by the
নেতাজি নগর।
this was allotted by the
refugee. Respondent number 4 is to allot.
You must
Issue.
file an application before the.
by the
respondent board and that-
fourth respondent upon acquisition of the same, since they are immigrants who migrated into the state of West Bengal. Stop. The petitioners have been paying tax in respect of the said plot. Stop. The petitioners seek to submit a comprehensive representation before the fourth respondent for issuance of patta in their favor in respect of the plot in question. Paragraph, it is submitted on behalf of question and pray for a direction upon the concerned authority to consider the application at the earliest. Paragraph, it is submitted on behalf of the respondents that the fourth respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive application before the fourth respondent within 7 days.
Within 2 weeks.
Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the application within 1 month,
Because
2 months,
the prosecutor.
within 2 months from the date of receipt thereof. Let it be 6 weeks.
Yes, ma'am.
Because
Upon
within-
hearing the petitioners.
Absolutely. Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, pending disposal of the application by the concerned authority, comma, there shall be an order of status quo upon all the parties concerned with the plot in question in respect of possession, nature, and character of the plot as on this date.
Grateful. Such decision is to be communicated to us.
Or decision taken by the decision taken by the authority shall be communicated to the petitioners within a week thereof.
Grateful. Deeply obliged. And
এটার আগে করবেন না।
extremely obliged.
Status quo আগে। তারপর disposed of which apply. Yes, next.
Number 21.
Actually, I'm for the petitioner. Upon mentioning this matter has been listed, very urgent matter, Lordship. I've already hand served to the department. Matter was mentioned on Friday and listed on this day, Lordship. Difficulty is that I am the absolute owner of the plot of land by virtue of a registered deed, and I have my own porcha and record my possession before the local Gram Panchayat. Till date, I am paying the Khajna and Panchayat tax till 2023. Despite of everything, Lordship, suddenly a notice has been issued to me that which has been annexed in page number 74, Lordship. Under section
There should
4.
be a separate set of lawyers for the sixth and seventh respondent, the HDCL.
Lordship, I have served them through speed post. And rest of others,
One, I find it's not delivered. Item dispatch, none of them are served.
Lordship, 1, 6 and 7.
You've not served.
Lordship, I have served but not delivered due to Saturday and Sunday.
That is not called service.
Lordship, but
When can you serve and come back?
Lordship, any date, Lordship, may be fixed, Lordship, but difficulty is that there is kindly turn to page number 74 once. There is an order of demolition But this order is not relied, this order actually against the act itself, Act of 1962. Worship, may I place once?
You have been directed to vacate. So this is not really an order of demolition.
I have to
There
direct
is
it
no
to vacate,
immediate
but this
effect.
order is not sustainable under the act itself. Worship,
Maybe, but serve and come back. There's no imminent threat on you. So please serve and.
any date, Lordship, short date by this week.
Since, you can take this back. Since service upon the respondents is not complete, let the matter stand over till 26th June.
There should be any short date. Already twice police has informed me, a local police station has came to my home, and any short date, Lordship.
It is pending. 26th June, serve and come back. You could
Lordship.
serve before that, isn't it?
Deeply obliged.
Number 22.
But pursuant to your lordship's earlier direction, I have further served, and lordship all have received. Lord, I have challenged,
Give you a minute, please.
my lord.
There are private respondents also?
No, Lord, there is no private response,
Only the state.
only the state. All other state respondents.
All of them are served.
Yes, my lord. In the track record, I mentioned the respondent numbers.
Yes, so may I request,
No, madam, Mr. Answer.
I can find
Answer,
Mr. Mondal. Mr. Mondal, may I request you to
Answer, sir.
appear? May I request you to appear in this matter? State has been served, no one is appearing.
একটা কপি দে আমার কাছে এখানে আমি দিয়ে দেবো আপনাকে
Mr. Mondal, appointment regularized. Yes.
The point to involve in the petition is that the land of the petitioner was acquired under the LA case of 6970. That the land was originally belonged to his father. Number petitioner applied for a certificate under land user category. He filed a writ petition initially before this honorable court. This honorable court directed the authority to take steps. Now, the district magistrate, after going through the report of the screening committee, recommended the petitioner for issuance of land user certificate. Now, by the impugned order, the director rejected such prayer. Now, if you kindly come to the rejection order, page 107. ওটা করেছে হচ্ছে জয়েন্ট ডিরেক্টর অফ এমপ্লয়মেন্ট but he has rejected. Collector recommend করেছে. Now, kindly come to the first, second, third, fourth paragraph. It says, in terms of clause 3 of notification number 301 EMP 1M 10/2000 dated 21st August 2002 of the Labour Department, Government of West Bengal, the provision of enrollment of land user in the exempted category shall be applicable only in respect of cases where the land in question has been acquired by the state government on or after 17th October 1977. In case land acquired before 17th October 1977, the above provision shall not be applicable. The reason behind such restriction. Next page. The reason behind such restriction is that the first government order regarding reservation of vacancy for exempted category candidate and inclusion of the land user in the exempted category was issued on 17th October 1997 by the Labour Department. Before 17th October 1977, there was even no concept of exempted category and inclusion of land user in the exempted category. As such, there does not arise any question of enrollment of the land user in the exempted category where land in question has been acquired before 17th October 1977. From your aforesaid letter, it appears that the possession of the land of the petitioner father was taken on 5th March 1970. Obviously, the land has been acquired by the government even before 5th March 1970. In view of the above fact, your petition is not eligible for enrollment. Number, I have challenged the validity of clause 3 of the state notification. That is, I have annexed in that notification. That is page 111. Number clause 3, 1, 2, 3. Number the last paragraph in clause 3.
Yes.
This shall be applicable only in respect of cases where the land in question has been acquired by the state government on or after 17th October 1977. But I've challenged this portion of the notification as well as the impugned order.
What is your ground for challenge? Because
Well,
this is a policy decision.
Well, I've challenged the constitutionality and validity of this notification.
What is your ground? This is
Well,
a policy decision, sir.
The policy decision cannot be, Lordship, override the constitutional right because my land has been acquired rightly. The government cannot come into a cutoff date that from 1997 I will give from 1997. Before 1997 I will not give.
When have you made your application?
But I've made my application in there is no specific but kindly come to page 51. This is a certificate issued by the LA collector, page 51. This is of 2008.
Your letter dated 22nd June 2017.
No,
This is stated in page 107.
no, this is a subsequent. The writ petitions was pending. I'll kindly come to page 51 initially. Page 51. This is a certificate issued by the LA collector.
You have received compensation. No dispute.
I've received the compensation, yes, no doubt about that. Page 51 is the certificate issued by the LA collector. Now, let kindly come the earlier order, page 62. The High Court. Justice Shamit Talukdar.
This is the same petitioner.
Same petitioner. Subrata Maiti. The earlier order of this court, page 62. 18th May 2011. Pursuant to the state solemn order, page 64, the district magistrate has taken a decision. Now, the relevant paragraph is page 65. Number is here, district magistrate found me eligible.
This is for payment of compensation.
No, kindly see the paragraph 5. Paragraph first, second paragraph. The screening committee of Egra subdivision has recommended the case of the Sri Maiti as land loser, wide memo number. Therefore, I am the opinion that Sri Subroto Maiti is land loser as per LA case number, and then therefore I hereby direct notice under 93 indicate that the fact of payment, compensation, and other necessary particulars on the body of the notice under seal and signature of the additional line. But unless I get that document, I cannot proceed further. That's why these documents were supplied to me. And thereafter, I moved another writ petition before this honorable court. That the order copy is at page 86 is a type copy, my lord.
Yes.
Number it's a long order. If you lordship Kindly come to page 88.
Yes.
The paragraph starts with thereafter Executive Engineer Conta Irrigation Division, Purba Midnapur, wrote letter to the Superintending Engineer, Western Circle Irrigation Waterways Directorate, Paschim Midnapur, for recording petitioner's name under exempted category for getting employment. Nothing was done. Ultimately, Block Development Officer, Bhagwanpur 1 Development Block, wrote letter to the Subdivisional Officer, Egra Purba Midnapur, along with all details report of Sri Maiti and financial status for taking action, but till date, no action was taken. Therefore, there is no dispute as regards to the status of the petitioner. Accordingly, the concerned respondent, SDO Egra, Purba Midnapur, is directed to record petitioner's name under the exempted category and to give preference at the time of giving his employment. Accordingly, Subdivisional Officer, Egra Subdivision, Purba Midnapur, is directed to issue certificate in favor of the petitioner under exempted category, and petitioner is permitted to take appropriate steps. The certificate to be issued by the SDO Egra Purba Midnapur within 3 weeks on the date. But pursuant to that order, the page 90, Subdivisional Officer wrote recommend the same to the district magistrate. Malada, you read for your lordship with reference to above and on verification of relevant records in the office. This is to put forward for your kind perusal that a priority list containing the name of the above Sri Subroto Maiti was prepared by Subdivisional Screening Committee, EGRA, in terms and as envisaged by Note 3.1 and 3.4 under Labour Department notification dated. The said list was duly forwarded to your kind end under its office number such and such. A copy of the said list along with the recommendation, now this has been done. Thereafter, kindly come.
Up content.
No, they have kindly come to page 92 thereafter.
Yes.
It's written by the additional district magistrate to the petitioner. This to inform you that your prayer for enrollment of name under exempted category as land loser has been recommended by the EGRA Subdivisional Screening Committee and approved by the district magistrate, Purba Midnapur. The list with name of eligible candidate has already been sent to the Joint Director Employment Midnapur District at such and such for taking necessary action for their end. Hence, you are directed to appear before the office of the Joint Director of Employment Midnapur District such and such office hour on any working day along with the following document: testimonials in originals and one set attached copy of the same and other documents. Ultimately, the impugned order came. This follows the impugned order, that is page 107, which I showed to your lordship.
Lordship, the district magistrate is the competent authority to issue the land loser certificate.
The authority continues to say that he is entitled to the land loser certificate.
Lordship.
Finally, in the last order, they say that he is not entitled. So I think you need to go through the documents. Please serve a copy to the engineer, along with all the annexures.
Yes, I'll serve him.
And please take instructions and come back. Affidavit of service. None appears for the respondents, despite service. Mr. Mondal, regularized. It is submitted on behalf of the petitioner that though the petitioner was held eligible for inclusion in the exempted category as a land loser pursuant to earlier orders of this court, comma, the Joint Director of Employment, comma, West Bengal, comma, by an order passed on, by a communication made on 13 July 2017, comma, has informed the petitioner that he is not eligible for such enrollment. Stop. The enrollment in terms of clause 3 of the notification number 301-EMP E capital, EMP slash 1 capital M hyphen 10 slash 2000 dated 21st August 2002. Stop. The relevant clause of the notification as well as the reply issue, as well as the communication issued on 13th July 2017 are assailed in the writ petition. Paragraph, learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 6th July.
As you wish. মাত্র আমি দিয়ে দেবো আজকে পাঠিয়ে দেবো।
পূর্ব মেদিনীপুর
হচ্ছে হ্যাঁ পূর্ব মেদিনীপুর আমি আজকে পাঠিয়ে দেবো।
Number 23.
Yes, 23. Anyone for the petitioner? None appears for the parties. No accommodation is sought. Dismiss for default.
Number 24.
Mr. Khan is appearing on behalf of the petitioner, Lordship. On his ground, Lordship, I appear only not today, Lordship.
Not possible. You are appearing for a response. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 23rd June.
23rd June.
Number 20. Number 25.
Yes, 25. Anyone? Anyone in 25? None appears for the parties. No accommodation is sought. Dismiss for default.
Number 26.
Your Lordship, 24. I'm praying for only not to, your Lordship. Senior advocate is engaged in court number 1, your Lordship.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading
That
on
would-
28.
Instead of not today, kindly make it not this week, Lordship, because I have to file one.
28th June. 28.
Meantime, time be extended to file the report, Lordship.
On prayer of the respondents. Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as called for. On prayer of the petitioner, the matter is adjourned.
Obliged.
Next.
Number 27.
Lordship, I am on behalf of the petitioner. Lordship, here the property in dispute.
Mr. Bandopadhyay, Shishanda Bandopadhyay for the respondents. Anyone for the respondents? No one.
Lordship, may I submit? Lordship, here the property in dispute is a private property, not a government property. The respondent authority said that the property has been acquired by
please inform the state about the adjourned date so that we can take up the matter.
Number 28, that I appear on behalf of the petitioner.
Yes.
That, yeah, the subject matter of challenge.
What about the respondents?
Respondents, Sarvachi, we get the affidavit of service shop. I have.
They appear on this matter. Yes, Mr. Raja Shaha and Mr. Shamimul Bari. Where? In fact, it was restored on the earlier date.
Yes.
So let there be a date. Please inform them.
Kindly fix it of any date, my lord. I appeal to my lords because it.
None appears for the respondents. Let the matter appear under the same heading.
Excepting Monday and Wednesday, because my learned friend some difficulty, you are watching.
27th? 27th is a Tuesday.
I have no.
27th June.
My lord, in the past item, my lord, we have given him not that is the Xerox certified copy.
Xerox copy, my lord, no original copy has been found.
I've heard the matter. Please come back on the next day.
Well, otherwise, my lord,
Tomorrow, my lord,
they will not take up the appeal, my lord, unless it is original order, original certificate.
you also only modified that Xerox are still holding. And it will be filed of that Xerox. Still holding. Copy which was handed short.
Order has been typed also. It has gone back. Mention tomorrow, I'll again consider.
Your lordship,
Mention because the order has been typed already. First matter, we are in 28 now.
May I submit one thing, subject to what falls for my lord's kind consideration. Your lordship fixed the matter on 27.
Yes.
Now, my lord, if it can be done in the earlier week, I appeal to my lords. This is on all the basis of instructions. I have no difficulty in nothing. Any day which suits my lords, that is my convenience.
Earlier date is next week. Next week there are several matters. 27th is the week after that.
It's a week after. So if it can be done in the next week.
What is your urgency? Is there any imminent
Miller,
urgency?
there is some urgency. Why? Because the petitioners, Miller, they are carrying on business of pisciculture. They have various Miller tanks. Now, Miller, these water from the tanks, these are getting stagnated. And Miller, the bills in which are being possessed by the petitioners, they cannot run on their business of pisciculture. Now, on an earlier occasion, they requested the authorities concerned to look into the matter and Miller to take steps so that Miller, the matter can be, the particular business can be run conveniently. A learned single judge of this court directed Miller to consider the representation, pass an order, reasoned order. Now, thereafter, Miller, an order was passed wherein the actual limb of the particular dispute that was not touched by the authority, but Miller, they say that you are not the owners. I have put my record of rights in the present petitioner showing that these are the particular Miller documents and these are the things. This is the subject matter.
27th is a week after this.
I leave it to my lords.
Come
I am
on,
very,
the past matter may be listed, my lord, tomorrow, my lord, has to be mentioned, my lord.
How can it be listed like this, sir? I cannot do that.
But otherwise,
First matter you are mentioning at this hour of the day. Mention the matter tomorrow, I'll consider. Let me see.
matter may be listed, my lord, tomorrow, my lord.
How can it be listed tomorrow after an order has been passed? Can it be done under the law? Please do not make submissions which cannot be acceded to.
Contempt application item number 78.
Yes, applicant. First step. It's appearing for the first time.
First time, my lord.
Please serve and come back.
My lord.
The applicant petitioner is directed to serve a copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 20th July.
My lord, can it be fixed on 7 July when the other contempt matter on the same causes?
It's on 7th,
7th, my lord.
7 July.
Grateful.
Item number 79.
Madam, for the petitioner. And at the last occasion, personal lordship's order, I have served upon respondent number 4 and 5 afresh. Both were returned because they have left. And Mr. Sen, my elder senior brother, was on the appearing for the state to file the affidavit. That affidavit, he has served me a copy.
But this is the
And,
report pursuant to my lord's order.
Yes, yes, I have received the copy.
Today,
My lord,
you've received the copy today.
man,
You seek to use an exception to this? No.
no,
Not
it's
necessary.
matters of records, as Mr. Sen submits on the last occasion.
Yes, so
So this
please place your
fraudulent
case.
transfer will be set aside. The,
Yes, what is the matter about?
Malad, a fraudulent transfer by respondent number 4 in favor of respondent number 5. Respondent number 4 is the original borrower of the petitioner, L&T Finance. The vehicle taken on hypothecation. The fraudulent termination of hypothecation document has been submitted to the RTO. And we have lodged complaint that was recorded by the RTO,
You are the financer.
my lord, the petitioner.
There was actually a direction for affidavits.
Earlier, my lord, we have been served, if your lordship can recall, one opposition from one of the respondent to which we have filed reply. But your lordship found that they have not even submitted the original opposition. The respondent number 5 used an affidavit in opposition. We have received copy and we filed our affidavit in reply. But thereafter they fled away.
The state hasn't used an affidavit. in this
No,
matter.
no.
So
State,
it's a
my
matter
lord,
of- Mr.
pursuant to my lord's order,
Yes.
Mala, we have just now,
report.
Mala, handed over the report because, my lord, on the very first day, my lord, I submitted to your lordship that it's a very, my lord, the transaction entered in 2009. There was no computerized system there that the data be recorded. So whatever the manual system, whatever be, my lord, that can be retrieved, that can be produced. But now it appears that nothing is available, except the 2 or 3 documents.
One of them is my complaint that is available.
I think, my lord, kindly come to paragraph number 4 and onwards, my lord.
Of your report?
Yes, my lord. It appears that on 27th February 2009, 4,000 was deposited
with the office of the RTO for transfer of the vehicle on 27th February and 2009. 100 rupees received towards fees for hypothecation termination.
Yes, that is.
So
But
that
they
means the
say-
hypothecation was terminated in that case.
They say that it has not been terminated, whether our office record says it speaks that a sum of rupees 100 received towards fees for hypothecation termination. That means that hypothecation termination letter, after having been issued in favor of the registered owner, he produced the same before the authority for cancelling the termination. And this is that fees.
Yeah, and that document is disputed by us.
That is
Submission is different, of course.
बोलते दाओ मैं कि page please बोलते दाओ. And third, history of transfer of ownership showing the fact that Kamal Khan, being the respondent number 4, remained the owner of the said vehicle for the period from 27th March 2008 to 26th February 2009. That means prior to the transfer to the other private respondent. So record shows that prior to the transfer entered into with the records, that Kamal Khan was the registered owner. After that, it has been transferred. Now, the writ petitioner's case is that they, being the financier of the said vehicle, that the vehicle was subject matter of the finance, and without obtaining the no objection certificate as required under the law, the vehicle has been transferred and registered in the motor vehicle, my lord, the records. Now, our record only speaks about the transfer fees received and recording of that no objection certificate issued by financier, that rupees 100 at the 2009 also received, and nothing more. So now, my lord.
So that sufficiently indicates that the hypothecation was terminated.
Yes,
Well,
yes.
Yeah,
Yes.
আপনি বলেন।
When fees received, when no other document, then my lord, some evidence is also evidence. My lord knows that.
Yes.
So when there is some evidence in support of the transfer and the legality of the transfer. And 2009, today we are in 2023.
Now, my lord, in case of hypothecation, there is a special provision under the Act, section 51. Is the hypothecation, how it will be terminated. I have stated in paragraph 18 onwards in the writ petition that in case of termination of hypothecation, form number 36, 35 and 36 has to be issued.
We are not disputing.
Now,
the question
document
is
annexed at page 47 to the writ petition by the respondent number 4 for such as form 30, which is not in case of hypothecation. That is in case of normal transfer.
কোত্থেকে পাচ্ছ?
Writ petition.
Writ petition.
Page 47. Page 47. On the basis of this document, this 100 rupees transfer fees was termination of hypothecation was submitted.
No, whether there was, my lord, any other documents or not produced by the, my lord, the transferor or the transferee, as the case may be, my lord, we do not, because since nothing is available in the record, only thing available, no problem. No problem.
Because
He
the
has to.
respondent number was fraudulently got this transfer by submitting form 30 instead of form 35. If RTO's record is not there, so I'm helpless.
In fact, my lord, it is between the writ petitioner and the private respondent.
Absolutely.
But transfer has been made by the
My lord,
RTO.
we cannot develop either of those parties' case.
And unless it is shown that NOC was not issued and, I mean, the private respondents
that has
are the necessary answering
But
respondents.
He will fade away. He did so much of, there are other issues, so I can't bring it. He did lot of such fraudulent transfer under RTO Barashat. That is point number 4. Anyway.
The RTO has done the
My lord,
job
this
on the basis of documents.
expression fraudulent, kindly consider, the moment he expressed that fraudulent transfer,
Of course.
my lord, he has to prove it.
I
That
annex
was
the
a
document, Form
Allow him
30.
to complete,
টেবিল
sir.
বাজালে কি মামলা করা হবে কি
Form
আছে?
30.
My lord, the thing is this, that it's a case that where in 2009, the transaction was recorded. Now, the thing is this, that the private respondent has not come forward to my lord to either, my lord, to contest the case or to put any evidence in support of his claim. Now, the particular expression that there was some fraud or fraudulent, we do not admit this because our record shows that the document 4,000 rupees, my lord, that it appears that the original register, my lord, in whose favor registration was, that means the registering, I mean the person, the registered owner, he, my lord, paid the said. Now, my lord, rupees 100 received, it appears from the record that rupees 100 received towards recording the said fact of termination. Now, these two things, my lord, corroborate that transaction was, my lord, that lawfully entered into. Because today we have no other document. Now, my learned friend, either he can produce, my lord, any evidence in support of his case that yes, this is the letter addressed to, or this is such and such thing, that yes, that no NOC at that point of time was produced. Now, my lord, practically speaking, now it's a case of evidence. To what extent the evidence should be, my lord, adduced by him or by private respondent. But so far, the RTA is concerned. RTA has produced that these are the available records in support of the said transaction after this so many
Very
years.
difficult to help the petitioner at this stage.
My lord, let Mr. Sen
না, আমার করা হয়ে গেছে, আমার আগে বলার কিছু নেই। তবে আমার
মানে the special
fraudulent
provision
করলে আমাকে লাফাতে হচ্ছে।
না fraudulent বললাম এই কারণে rupees 100 payment of money receipt is available with the RTO.
And
the document on the basis,
service of the private respondents is not complete also.
well, they have left. Tuma Mujumdar, the respondent number 5, who had filed served me a copy of the affidavit in opposition.
This is addressee cannot be located.
Both are the same endorsement.
So this is not due service.
Service was not come because it was returned.
So you have to find out
And
the-
I don't have a respondent number 5 is a stranger to the petitioner.
Going for substituted service.
Paper publication.
Because they are the
Paper publication.
answering respondents. Service has not been.
But
completed.
respondent number 4 is the main key person, my borrower. We had used Form 30, and this is the duty of the RTA under the MB Act to call for a hearing. We have filed our objection. That was not even heard since 2009.
At present, both are the
That was acknowledged by the
interested
RTO.
person. The transferor and the transferee, because transferee, my lord, has entered into the shoes of the transferor. So now both are interested person.
Mr. Chatterjee was appearing for the 5th respondent
Once earlier,
sometime in 2011.
yes.
He may not be appearing now.
No, naturally, if brief has taken away.
Please complete service and come back
Then
because
kindly direct for
unless
substitute
they appear, I don't think the court
service.
can help
Kindly
you.
direct a substitute service and order be passed.
You have to file an application for substitute service.
All of that, your lordship can also.
Since service upon the private respondents is not complete, let the matter stand over till end of July. 26th July.
My lord.
And my lord, kindly record that the RTO 24 Parganas, the secretary.
Today you have filed the report.
Yes,
isn't
yes,
it?
yes.
My lord,
kindly
one line,
Report submitted by the
Secretary RTA 24 Parganas North has filed the report, my lord, in terms of my lord's earlier order. Dated April 11.
report in the form of affidavit submitted on behalf of the Regional Transport Authority 24 Parganas North is taken on record.
get.
Taরপরে in service.
And copy of the report has already been handed over. Yes. To my lord. Not a record.
My lord, one more indulgence I am praying for. On my oral, if on my oral submission, liberty be given petitioner to
Cannot be done because this is not service. You have sent once and it shows that it is probably insufficient address.
my lord, at least petitioner be at liberty to take steps for service.
It cannot, I have stated that. I've stated
The
that.
agent for completion of service.
Yes, I've stated that since service is not complete, it is adjourned.
My matter
Yes,
will
next.
appear, lordship. কবে আসছে?
26 জুলাই।
26 কবে আসবে?
26 জুলাই।
Next.
Number 80.
আর এখন যে একটা fixed matter আছে।
Here also service was not complete.
Service has been completed. Affidavit of service. কপিটা দেখুন সাপ্লিমেন্টারিও জমা দেওয়া হয়েছে আর বলা হয়েছে আজকে affidavit।
Who is appearing for the respondents?
Because on the last occasions also not appeared, my lord.
Originally ওখানে
My lord, here the case, my lord.
আগের অর্ডারটা দেখে দিন ওখানে কে ছিল ওই পেজ 8টা ওখানে ছিল অশোক কুমার চক্রবর্তী সুরজিৎ কুমার অরিজিনালি অশোক কুমার চক্রবর্তী আর সুরজিৎ কুমার
My lord, my lord, in the interim stage, my lord.
Please give me a minute.
Then
Please
Mr.
give me a minute.
Yes. Supplementary affidavit at page 8.
Anyone here who appears for the railways? Yes. This is a matter where the railways have been served. They are not appearing. May I request you to appear for the railways? Please serve a copy of the writ petition
Yes,
to him.
yes. That a copy did.
সাপ্লিমেন্টারি কপি দেবো নাকি সাপ্লিমেন্টারি
Both supplementary and additional.
Because you are relying on both.
তোমারটা দিয়ে দাও আমার থেকে দিবে।
তাহলে আমার কপিটা দিয়ে দিতে হয় বাট ইট ইজ আ ওয়ার্কড আউট কপি
লাগবে না। Later are hearing a retention in
ওয়ার্কড আউট কপি তো
তোমার কি দরকার নেই। That's it. Supplementary. A supplementary and this
Supplementary I have
repetition.
given. This is the
Let him come back with instructions.
Yes, madam. Yes.
Yes. Please come back with instructions.
Yes.
Affidavit of service. None appears for the respondents despite service. Owner Mr. So-and-so, owner নামটা নিন। Regularize করুন, copy service direction. Paragraph, learned counsel for the respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 7 July.
Yes.
Let it be, my lord, regularized, appointment be.
I am doing it. Yes, it's done. I'm regularizing your appointment. Who will regularize the appointment?
My lord, this is Ministry of Law and Justice.
Ministry of Law and Justice will be requested to regularize.
My lord, that is the authority to, my lord, make the appointment, my lord, the regarding.
Yes.
Full nomenclature টা লিখে নেবেন। Ministry of Law and Justice, তারপরে কি পুরোটা লিখতে হবে। Please give the full nomenclature of Ministry of Law and Justice.
আপনার নামটা দিয়ে ওটা দিন।
Absolutely, I will do that.
Yes, next.
Number 81.
Lordship, I am appearing on behalf of the petitioner. Petitioner. Lordship, this is my sir.
What about the respondents?
I serve.
Service complete.
It's a very short matter.
Have you completed service?
Lordship, if your lordship.
Mr. Debra, may I request you to appear in this matter? State has been served, the Transport Authority. Please serve a copy of the writ petition to Mr. Debra.
Lordship.
Will you be able to deal with the matter today or you need a date?
Lordship, I am applied for permanent contract carriage permit on 19 August 2029 in respect of the route Diamond Park, Taratola. But the authority did not accept my application. Kindly direct the authority to accept my application, nothing else, Lordship. Contractor, auto. Yes, application along with fiscal fees, I will come to the. I will serve the petition.
Where is your application? Shall I pass an order, Mr. Devra? Where is your application?
29, Lordship, application.
Page 29?
29. 29.
Auto rickshaw permit,
You've deposited the fees, prescribed fees?
I will, at the time of.
Oh, you have not deposited?
No, Lordship, they will not accept my application. That's why I will not direct them to allow, accept my application. I will pay the deposit fees.
Affidavit of service, none appears for the respondents despite service. Mr. Debra, you be regularized. The direction for service of copy. It is contended on behalf of the petitioner that the petitioner applied for issuance of contract carriage permit before the concerned authority on 19th August 2019, which has not been accepted by the authority. Stop. The petitioner prays for a direction upon the concerned authority to accept and consider the said application upon payment of prescribed fees by the petitioner. Paragraph. Learned counsel for the respondents submits that the secretary.
Yes, Lordship.
Secretary accept and considered by the RTA board. Accept. Secretary. This one number 2.
2 and 4. This one is 4.
Oh, secretary, this one
This
4. Secretary RTA Kolkata.
The fourth respondent be directed to accept the application for consideration of the same by the
Along with fees.
RTA board in accordance with law, subject to payment of requisite fees by the petitioner. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to accept the application submitted by the petitioner for consideration of the same by the RTA board within 1 month. Within 1 month from the date of communication of the order, subject to the petitioner depositing the requisite fees for the same.
No, Lordship.
Upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereafter. Disposed of.
Lordship, your Lordship, direct
Well, at the
respondent
time
number
of-
4.
Well, at the time of submitting the application order, my lord, he can annex the application copy of the application. Otherwise, my lord, you are to
Lordship.
19 application, my lord.
Lordship.
In accordance with law পরে করুন যেটা যেটা in
Along with the
accordance
lead
with law
application.
বললাম না in accordance with law বললাম যেটা submit a copy of the application in prescribed form before the concerned authority along with a copy of this order
Lordship.
at the earliest. Decision taken by the authority পরে হবে এটা। তারপরে disposed of. Yes, next.
Along with my junior.
Along with the junior of his choice.
Number 82.
My lord, item number 82, my lord, I appear for the petitioners, my lord. By the last order, my lord, we were directed to file an exception to the report filed by the railways, my lord.
Sought to use an exception. You would
Yes,
not
we had
have
sought,
acted.
we sought for liberty and the liberty was granted, my lord. My lord, the exception is ready, my lord. I have the draft with me. The difficulty is the deponent is not in West Bengal, my lord. He has gone outside to visit his family. He's expected to be back on Monday, my lord. If my lord permits, I can serve an advance copy to the other side, my
Do
lord.
that, please, so that we
And
can
the
deal with it.
matter can be fixed for hearing in the next week, my lord, subject to convenience of the
Because your
court, my lord.
interim order runs till 30th
30th,
June.
no,
So
so
let
we-
there be a date prior to that.
Yes, my lord. And my lord, just one other submission, my lord. With this, my lord, there are two similar matters, my lord, where the exception has been already been filed, my lord. So I can hand over the case details, my lord. If those can also be fixed with this matter, my lord, I'm led by Mr. Basu in all three matters.
In those matters, my lord, these reports and exceptions were treated affidavit in opposition, affidavit in reply by the last coordinate bench, my lord. So those matters will appear for hearing, my lord. Here it can appear, my lord.
If all three can be fixed
Let
together,
this
my lord.
be decided on at the motion stage. We'll deal with the other matters later.
Even there, my lord, we have filed an
So I have
exception,
to
my lord.
shift this matter to the hearing stage then.
All three can be taken up together, my lord. That is my submission because Mr. Basu is leading me in all three matters, my lord. Similar submissions are to be made, my lord. Only the facts are a bit different, but the rest of the submissions are
The
the
other
same.
matters are appearing under the heading hearing.
No, my lord, it was a,
It has been directed by the honorable judge in cooperative, in coordinate bench, my lord, that, my lord, the matter be treated for hearing and the affidavit report will be treated in affidavit of opposition and the exceptions will be treated in affidavit in reply.
my
They
submission,
become hearing matters.
all three matters can be heard together, my lord. That is my submissions because, my lord, same submissions will be made, my lord, and the same counsels are there, my lord.
Come back with the exception on the next date.
Yes,
I
my
have to
lord.
see the other two matters before I fix any date for it.
My lord.
They are running in the monthly list.
They are not running in the list, my lord. That is the
So
difficulty.
mention tomorrow. I'll bring them into the supplementary list and
My
we'll
lord.
deal with them.
My lord. Grateful, my lord. I have served an advance copy, my lord, may
Please do
record it.
that,
to the
please
order.
do that.
I've served it, my lord.
Learned counsel for the petitioners seeks extension of time to use the exception to the report submitted by the respondents. Paragraph, let the matter appear under the same heading on 28th June.
Advance copy has been served, my lord, if my lord records it in the order, my lord.
An advance copy of the exception has been served upon learned counsel for the respondents in court this day.
Grateful, my lord.
আপনি ওটা দেননি কিন্তু
দিচ্ছি
Next,
নাম্বার 83
83, my lord, so far. State
petitioner,
respondent is concerned, my lord. I think, my lord, I have concluded. Now, my lord, they were, my lord, giving reply.
who is appearing for the petition?
My lord, Mr. Sankarnath Mukherjee is leading me, my lord.
Yes.
Written arguments is ready, my lord.
By written arguments, make your arguments.
My lord, kindly short passover may be allowed.
Passover is not possible, sir. I'm sorry. Shall I give you a short date?
Tomorrow, my lord.
Not tomorrow.
Tomorrow, my lord, I have difficulty,
Not
2 p.m. My lord,
Friday,
this
my
Prayer of the
matter, না, না,
petitioner,
আমার
the matter
কাল
is
পরশু
adjourned.
দিনই হবে না।
Let
তো
the matter
Friday,
appear under the
Friday.
same heading
এটা তো
on
ছেড়ে দাও,
4th July.
4 July।
My vehicle is keeping idle, my
তো
lord.
মামলা করো। আশ্চর্য।
4th July is a short date.
My lord, my vehicle is keeping idle, my lord. It was
মামলাও
kept in
করবে
their
না,
custody, my
vacancy-
lord.
It is idle for all these days, so wait for a little more time, sir.
No, my lord, I am
Yes, next matter.
short time, my lord.
This is a short date. 4th July is a short date. Next,
number 84
84, my lord, Mr. Arijit Majumdar.
yes, you are the petitioner, sir.
I'm petitioner in another matter of 86, 84 and
86
are related,
my lord.
My lord, Mr. Arijit Majumdar is appearing for the railways. He is engaged in court 32 before the division.
My lord, may I only
I'm
say
already
one
paying
thing,
for
my
not
lord?
today.
May I only say one thing, my lord? 86, I am the writ petitioner, item number 86. Actually, we have
initiated the proceedings against the railways for non-granting of offer letter. Lordship, remember that matter, that we and the private respondent both are the joint proponents. But the railways were going to issue offer letter in respect of the private respondent only in item number 86. That we have resisted, my lord, there is an interim order. Now, subsequently, in item number 84, which has been called just right now, my lord, the petitioner therein challenged the entire policy. It says that it's discriminatory. Now, lordship, on a previous occasion, it was contended on behalf of the railways that they are going to likely to discharge the tender. And that is for the administrative reason. That is not for my fault or neither of the fault of the private respondent. So that is, and I
Do you have instructions in this matter?
I'm not appearing for the railways.
Let
now,
Mr.
only thing I want, my lord, my interest is only to the extent of the amount of earnest money which I have deposited with the railways. I think
My lord, as do I, my lord.
he is the private respondent. We both deposited 1 crore 80 lakhs.
The railway has to be here.
Now, if they assure us,
How can
Only
she is
days
not in a
adjournment
position.
for-
She's only asking for an
in
adjournment.
that case, my lord, 84 and 86 may be taken up tomorrow.
Not tomorrow, not possible. I'll fix a date.
Lordship, on the
My lord, if they may be kept together, my lord.
84
Yes,
and
I know.
86.
It has been wrongly recorded. Shantanu. 85 এর সাথে 86 ট্যাগ করেছেন 84 আর 86 হবে 85 is also
No, my lord, that is wrongly recorded. It should be with 84 and 86. Previous direction is also like,
এখানে 84 এর সাথে আছে এটা The same submission was made in 85 also.
85.
My lord, 85 is not the same.
The change.
Lordship, this was your lordship's order.
No, they are there. Both the orders are there. On prayer of the Shantanu, 84 with 86. It's a correction টা করে নিন 5 না 5 আলাদা। On prayer of the railway authorities, the matter is adjourned. Let the matter appear under the same heading. Let the matters, both the matters. Let the matters are adjourned. Let the matters appear under the same heading on 5th July.
5th July, my lord. Probably, my lord, only thing is required to be dealt is refund of the security deposit on this
Come
much
back
of
on
things.
that. Let us see. Yes, next.
Hi. My lord, in this matter, I'm appearing on behalf of the petitioner.
I have filed my opposition.
In the last occasion, I also filed a very written reply. I'm placing the fact in nutshell. The matter was heard several times.
This is a hearing matter.
Everywhere will be exchanged. My lord, in the last occasion, my lord, director, the matter will appear in the same heading. Can you see the last order of this honorable court? But I believe
Yes, it should actually appear as a hearing matter.
The matter was heard several times. But in the last occasion, my lord desired to dispose of the writ petition. So my lord, my senior lawyer friend, my lord, raised some objections, but that is my lord directed to file. So my lord, my permit has been cancelled.
Who is appearing for the state? You are appearing?
Mr.
I am
Naik,
appearing.
Mr. Naik.
Led by Mr. Naik.
Have you used your affidavit in opposition in this matter?
Yes, we also filed mine.
Yes, I
They
mean,
are complete? Affidavits are complete?
everything
So
is
let it appear as a group 7 hearing matter on the next day.
Because my matter is civil, in a civil occasion, matter was hard. So my lord, permit has been issued, I am suffering. So can you fix the
Maybe, but I'm
sorted, can you fix sorted, I have no objection. Very short, because already been hard several times. In the last occasion, my lord desired to dispose of.
107, another matter my learned friend has filed. I am praying, my lord, both the matters may be tagged together.
This,
New
this-
motion,
this
new motion
creates
cannot be taken.
confusion.
Yes.
Let this matter be taken up. It will be governed by the.
Separate issue. These are separate issues.
One after another can be.
Let, no, let this be taken up.
My lord, short that, my client is my suffering, because matter was.
No. Everything.
My lord, no.
প্রথমে করুন,
Suppose
since
the affidavit is আগে।
Since the
My lord,
issues
kindly excuse me one
in
second.
in the present writ petition is
না দরকার নেই এখন হবে।
different from that of WPA 23890 of 2022, comma, the said writ petition be detagged from the present writ petition. Another matter was tagged which has no semblance with.
107. No, same heading.
same issue.
Paragraph.
ঠিক আছে, ছেড়ে দাও না।
Affidavits are exchanged and the matter is ready for hearing. Paragraph, let the matter appear under the heading Group 7 hearing. June. 27 June.
Yes.
না না না, আমি affidavit জানি
Hearing, huh?
About 27.
Difficult.
Because very next day, my festival is Jua, so I shall go to my native place. So before that, before that.
Before that, not possible. In that case, 4th July.
4th July মানে 4th July.
Amlan, 4th July. Shantanu, Group 7 hearing. Yes, next.
87.
For the private respondent. जिसका नाम लिखो। हाँ, चलो।
Petitioner. Mr. Mukherjee for the petition.
Sorry, my lord, I was another court, your lordship has adjourned the item number 83. The next month. The next month, your lordship, that
A date has been given already.
4th of July, I think so.
Okay.
Well, long, my lord, this is waiting for my lord from November.
July is a sufficiently
Right.
short date, Mr. Mukherjee.
I beg your pardon, my lord, I was in another court, my lord.
Oh, that's all.
The
You are for
affidavit
the
of
5th
service.
respondent, the private respondent, you are.
My lord,
a-
I'm for 5.
87.
So we put it. No, the facts is that,
What
my
about
lord,
the state?
I'm for this.
the facts is that, my lord, I'm for the petitioner, my lord, the facts is that the petitioner when we purchased a vehicle under the lease agreement on the hire purchase agreement with the private respondents. Now, I'm not going to default, his vehicle was taken over or seized by the private respondent. You'll also will find. Then, my lord, it has been sold to a third party. Now, my lord, I made an objection before the registering authority, in which registering authority, the vehicle originally registered. That is, my lord, your lordship will find that page 16, straightway, the objection which I have raised. Now, my lord, the issue is that, my lord, under section 51, subsection 5, your lordship has got this. This registering authority, Hooghly. Now, my lord, the vehicle was registered with the registering authority, Hooghly. Now, my lord, I raised objection on the ground that even it is, my lord, the notice, I haven't got the proper information that it has been transferred. Thereafter, when I found that vehicle has been transferred by third party, that I have got the vehicle has been transferred by the registering authority. I made also the registering authority. But the Matha Bhanga at Coach Bihar. But the vehicle has been transferred by the registering authority Matha Bhanga at Coach Bihar. But it is originally registered with the registering authority Shiuri.
Hooghly.
Sorry, my lord.
Hooghly.
Yes, my lord.
They will sell if I fail to pay. That is the clause herein, in the notice. Now, they are selling. If they intend to sell, they can sell. In that event, the follows the provisions of section 51, subsection 5 has to be followed. In my respectful submissions, the objections which I have raised before the authority, that has to be considered by the registering authority itself. And your lordship kindly, subject to that, lordship kindly ask Mr. Devray. He is appearing for the state. Let him ask to produce a report. He sale proceeds. So far, my knowledge is that this has been transferred in form 29 and 30 under the central motor vehicles rules. This is a very peculiar thing. The vehicles which are not covered under the any hire purchase or hypothecation, simply there is no encumbrances or charges against the vehicle, then the registered owner can transfer the vehicle. My submission is that they may transfer the vehicle under the form 29 and 30. And in that event, vehicle must have to a clearance certificate from the finance. My objection is this: the vehicle which has been seized, your lordship will find that from they send the notice, the pre-sale notice. It is in their custody. So that cannot be possible to sell the vehicle by the registered owner if the vehicle is within their custody. So let the report be placed under which form also this has been sold. The form appended in the rules, central motor vehicles rules.
Yes, let the state respond, Mr. Devray.
First of all, before the state makes his submission, my lord, there are certain facts which needs to be placed before your lordship, my lord. The first thing is that admittedly there is a default in payment of the installments. The installment was allotted to the loan was allotted to the petitioner. An installment of 67 installments were supposed to be paid by the petitioner. They paid only 24 installments. Admittedly, they made default. First default they made, the car was repossessed. Thereafter, a settlement was made by the petitioner with the bank. The bank released the car subject to payment of the installments. Second time, once again, they made default. First default was made in the year, the car was taken possession in the year, in the month of May 2022. That was the first time the car was repossessed. It was released subject to payment of the installments. Once again, they made default. The car was again repossessed on 12th July 2022. They once again they approached the bank. They offered a proposal that we will not make any default. I will keep on paying, and with an undertaking that if I make a default, you may take possession and sell the car. This was the undertaking. This was the affidavit. With an affidavit,
You need to come back on affidavits. These documents should be brought on
certainly,
record.
certainly. Now, my lord, I'm just placing the facts. We made a demand notice to the petitioner to make the payment. They failed to do so. We sent a notice that, look, you have failed to pay this much of amount. You're a defaulter. I will sell your car. I will sell your vehicle. They did not respond. Neither they approached the debt recovery tribunal, which is the appropriate forum. They should have approached there. They did not approach. Ultimately, finding no other alternative, we sold the car by auction. A repo sold was made. We suffered a loss and the account was closed. Now the person who purchased the car through auction transferred nowadays it's called smart card. We used to know it as a blue book. So accordingly, that was changed in his name. Now the objection of the petitioner is that my consent was not taken. Why my consent has not been taken? The section is very much absolutely clear. It says that if you make default and the car is repossessed, I may give a letter to the registering authority that they have made a default, we have repossessed the car, and now we have sold the car. This much is required to change the,
And that was given.
that was the, because the moment a smart card is issued, hypothecation to a certain bank or to a financial institution, the name of the financial institution in the bank
Terminated.
is there. So the registering authority, the vehicle authority, the transport authority accordingly did their job and they transferred the name of the incoming purchaser as the owner of the vehicle. So this is the fact. I do not understand if they fail to make the payment, you did not take any action. Now you're coming before the court only on the point that these procedures were not followed.
The petitioner claims to have.
They
made
do
the-
not even,
made
they do
all
not
the
even
payments
want a.
subsequently.
Milord?
The petitioner claims to have made all the payments subsequently. Is that a?
No. They are still in default. They have not even made an offer that we will make the payment. So
Let there
what
be
is their case? I
affidavits.
fail to understand. If they
Let
have
there
failed to
be
make the
affidavits.
payment,
Let there be affidavits. There are several disputed questions of fact
The facts,
which need to be brought. to the court.
let them file agree, but the thing is that I am not the factual aspects. It is between myself and the private respondents, and that has not to be adjudicated by a court under Article 226. My question is that whether Section 51 subsection 5 has been followed. First of all, my lord, this is the questions related to law, not on the facts. Now, my lord, the dispute what has been with myself and my lord, my learned friend, that either has to be adjudicated under the arbitrations or by any other civil court. Now, my lord, my issue is here, my lord, I raise the objections, provisions is there. Whether the authority has complied with or not, let them say, let them consider my representation. And I need to know, my lord, this is not the issue at all. They are saying, yes, they have a right to sell my property. This is, my lord, whether I defaulted or not, that has to be adjudicated by any civil court. They send a notice that they will sell my property. Even if there is a part payment is there. Now, they are, whatever be the dispute they are raising here, that is not within the domain of the 226, my lord. So far, my knowledge goes. That has to be adjudicated either by the arbitration or by any civil court. And before that, they took the law in their own hand. They took up the vehicle.
The sale made.
Neither the law is there, nor neither the order of the court is there to take up the to take over the possession of the vehicle. Now, no civil court's order is there.
But they're not challenging the sale. That means they're not challenging the sale. They're only challenging the procedure
Yes,
adopted
yes,
by.
I am challenging the
I do not
procedure.
understand if the car, if you don't challenge the sale of the car, what purpose it will serve you by challenging the procedure of the.
Now, your lordship kindly
Let
come.
Mr. Debra
Now,
respond.
your lordship kindly see, my lord, kindly see, my lord. The central rules, my lord.
Mr. Debra, the primary question.
Dispute between my lord, financer and the owner of the vehicle. It is not, my lord, in the motor vehicles department.
Have your lordship
Sir,
kindly-
only give it answer.
Have you seen 51(5)?
51(5), I have to take a further instruction in this matter regarding complied or not.
A document is to be submitted as to whether this has been complied with.
এই তো পরিষ্কার বলছে তো তোমার refused to renew the issue a duplicate certificate, assign or refused to assign a new registration requirement. বলছি তো এখানে পরিষ্কার তো বলা আছে আমি ব্যাংক অথরিটি আমি তো দিতেই পারি ওখানে 51(5) বলছে তো কোথায় গেল
পারো না।
না এটা হ্যাঁ. And whom the registrar now entered into this agreement satisfies the registering authority he has taken possession of the vehicle. আমি তো আমার নামই তো আছে hypothecation. Hypothecation আমার নামে থাকবে।
hypothecation নাম
আমি ওই
has to be incorporated in the registration certificate.
The registration,
my lord,
the
that
registering
is-
authority has to be
that-
satisfied with
My
regard
lord,
to
that.
51(5).
Yes,
So will you come back with
Yes.
a report?
Yes, that is better.
Mine.
That is better.
Let him come back with, before we go
That I
into-
need, that I need.
before we go into factual aspects of the matter, let him come back with a report. Affidavit of service. The petitioner alleges violation of Section 51 within bracket 5 of the Motor Vehicles Act 1988 by the registering authority in transferring the ownership of the vehicle in question. It has been transferred in favor of the private respondent.
No, my lord, that he has not been made a party, my lord.
The vehicle, it's an outsider. It's an outsider.
Now, I do not know, without his presence, how can this proceed? my lord?
In
Because
favor-
an order in respect of something, yes. He
He'll be
needs to be made a
affected.
party. He needs to be made a party, my lord.
Because
Now,
he'll be affected.
yes, certainly, he will be affected by the order.
Kamla, you wanna- Last. In favor of a third person. Paragraph learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Will you implead the third?
But I haven't any knowledge in whose name it has been transferred because they transferred it.
So please think over by the next date, because
My lord, I will try, my lord, I will try. my
the
lord,
other
because-
person will be affected
My
by
lord,
this order.
my lord,
So he is a necessary party.
and my lord, your lordship kindly make it clear that
Matter-
the forms, my lord, let them
Let him
file
come
a
back with the
report, the
report.
forms which has been, my lord, used in transferring, my lord. Under the
Please
motor
come
vehicle,
back with the
central motor
comprehensive
vehicle,
report.
my lord, that.
Let the matter appear under the same heading on 7 July.
Seven.
My lord, any other day, my lord, 7 July, I will be not here, my lord.
11th,
11 July.
Kamla, 11 July.
I'm deeply obliged.
Number 88.
Who is appearing for the state? Mr. Ganguly.
My lord, on the last occasion, Mr. Osim Kumar Ganguly was appearing. Name was recorded in order dated 13/3.
It is recorded, yes, but today where is he?
My lord, for the last 2 or 3 dates, he is not appearing. My client is suffering, my lord. It's a simple matter, my lord, for deciding of representation. Only,
Make out, please, make your submission.
my lord. My lord, may I take your lordship to page number 12 of the writ petition, prayer B. My lord, representation is at page number 26, and extra P3. My lord, the relevant portion of the order is at page number 17.
Page 23 is the last page of your representation.
Page 20, my lord.
It starts from page.
My lord, P3, page 26, my lord.
This is your representation.
Fine.
You want consideration of the same.
My lord, on merits.
The particular none appears for the respondents. Paragraph, the petitioner seeks a direction upon the concerned authority to consider and dispose of the representation submitted by him on what is the date of your representation?
My lord,
21st September,
21st September.
on 21st September 2022. Stop. In view of the above, comma, the writ petition is disposed of, directing the
Page number 2, my lord.
second respondent,
My lord.
second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, since the respondents are not represented, comma, the petitioner is directed to serve copy of this order along with a copy of the representation to the second respondent at the earliest. Disposed of, which actually. Next.
No, 89.
Yes.
My lord, this is a dispute with regard to timetable. My lord, kindly come to page 61 of my bill. My lord, this is the last order of.
Who is appearing for the sixth respondent?
My lord, I have some. Okay.
Where is the service?
But I have already filed with the last occasion.
Sixth respondent, there is no service. The secretary of the association.
Six respondent, yes.
The secretary of the owners association. It's not served. I do not find it here. So please serve and come back. Since service upon the sixth respondent is not complete, let the matter stand over till 11th July. I gave the other date was 11th July, isn't it? So the same date? Same date? 11th July.
Lalmunda. 90.
The 90, I am for this.
Respondents?
90 my lord, I appear. 90 কি first time? আগে কোনো
Yes.
order হয়েছিল?
Maybe damage the instruction.
Oh,
Yes, what is the matter about?
But the petitioner had a permanent permit on the interstate route forward to Dev. Forward to Devar, my lord, which permit was, your lordship page 23. Your permit was valid up to 24th September 2020. September 2020. Page 23, well, right hand side at the bottom.
Page 23, right hand side bottom.
Permit renewed up to 24th September 2020.
my lord, may I tell one thing, lordship? I'm very sorry.
The documents are not legible. I cannot make out. The date is not
On
there.
last occasion, after going through my lord, page number 36, my lord, I'm very sorry, my lord. At page number 36, this is the, my lord, the impugned challan, whereby, my lord, after intercepting the vehicle, my lord, the motor vehicle inspector MVI, my lord, handed over this. Now, my lord, they have challenged this, and if your lordship kindly have a look at the just below the box, left-hand side offense charged with. Now, my lord, here, realization of motor vehicle tax, additional tax with 100% penalty for 17 weeks, retrospective effect from 13 March 2023, 1,79,567. My lord, this amount on the very first day, well, I'm very sorry, my lord, it fell from your lordship that the basis.
You are at page 36.
My lord,
36 is the insurance policy.
no, 36 annexed P7. Right, though.
For P7 is 38. In this brief, it's 38.
Maybe, my lord.
Yes.
Page,
P7.
my lord, but in my copy, my lord, 36 is the, my lord, that at the top transport department.
This offense is charged with, yes.
Yes, now offense is charged 1,79,567. Now, my lord, this, my lord, it fell from your lordship that there should be a breakup.
Of the
How
total
this-
amount.
Yes, how this figure reached. And my lord, the basis. Now, my lord, I receive instruction, my lord, by your text message. But the hard copy is not with me right now. If your lordship kindly take this matter any short day, my lord, because his vehicle is being idle because it has been seized.
13 January 2023.
Now,
my lord, the vehicle is
No,
in the-
I am taking time today for the
custody of-
first time.
I have to pay
That, my
regular
lord,
garage fare.
I missed it. Now, my lord, I can come before your lordship, my lord, except tomorrow, tomorrow and day after tomorrow.
Next week, my lord,
Next week. Instruction ওইটাই।
Affidavit of service. Paragraph learned counsel for the respondents
ও
seeks
আচ্ছা
to
breakup টা
submit a
দিয়েছে।
report in the form of
আমি ওইভাবে
affidavit in
কিছু
this
আজকে
matter.
দেখাতে পারি, হ্যাঁ। Fine,
Paragraph
100%
will appear under the same heading.
17
on-
weeks নেই। দেখো,
আপনি ট্যাক্স পেড 24/9/2022 পারমিট ভ্যালিড হবে।
হ্যাঁ, তারপরে তো গাড়ি ধরেছে, সিজ করেছে পরে।
26 June,
26 June,
Monday week.
my lord. Because here, my lord, admittedly, my lord, the period for the tax paid, my lord, that was, my lord, up to September 2022 of this. But the vehicle seized after that.
You will also kindly, my lord, record the assessment of computation of the tax.
Yes, yes, I shall.
That should be handed over to prior to that, so that
I have,
I can ascertain.
oh, you need an advance copy of the report.
Not report, only that statement. This is-
Omlan.
দিলেন ভালো হয়।
আমি দিয়ে দেবো, আমি দিয়ে দেবো।
Therefore, learned counsel for the state respondents seeks to submit a statement indicating
The basis and particulars
the
of the assessment
particulars
done by the
of
MBI.
the assessment of penalty made by the authority. Paragraph, let the matter appear under the same heading on same order form. Please serve an advance copy.
My lord, my lord.
That's why I'm appearing for
কবে আসবে?
respondent number 3 and 5.
13 June.
Yes,
I'm appearing for
13,
respondent number 3 and 5.
26.
the names have been expunged as far as I know. File the report and check.
3 and 5,
3 and
5 and 6 দিয়েছেন।
Oh, sorry, 5 and 6.
এটাতে
The file the report. Give me the file.
probably last occasion 5 and 6 has been
5 and 6 have been expunged.
expunged.
ফেরত দিয়ে দিন ওটা।
Get,
5, 6
আমি তবে দিয়ে
expunged.
দেবো। খালি তো একটু মনে করি।
Read up করবেন না। Yes, next.
91. I beg to differ, please, your lordship. In this matter, can on behalf of the petitioner.
Private respondent, yes.
Thank you.
আমরা আছি।
Right. Over. But here in this case, my lord, let us see the page number 21.
এই কোথায়?
In notification was issued.
এই তুমিও আছো?
My lord, that's what.
কোন তো? কোন
Page number 21.
House file.
Yes,
This notification was issued by the Transport Department, Government of West Bengal. On 27th November 2020. And this notification has been issued under section 16 TCA. In paragraph, Section 8, small I'm making it in a cut format.
Yes, yes.
68(3)(CA is the formulation of the route. Or 71(3)(A, or number of permit has been fixed. Under these two sections, my lord, this notification was issued. And name of the route, 15 number bus train, Ultadanga to Saputi at Newtown, via Ultadanga station, Putko, BNB, CA Island, Vidyasagar College, City Center 1, Vikas Bhavan, Purma Moi, Vipro, College Mode, Techno College, Newtown bus train, Rovindra Style, Unity Gate 1, UP World City, District. Line of the road, and nature of such AC minibus service. Maximum number of permit we issued 20. With the notification. After this notification, RTA Kolkata region at the last line. Regional Transport Kolkata region shall be the competent authority to issue permits for the route. Now can you see the next page, page number 23. Pursuant to the notification, another notification was issued by the Secretary RTA Kolkata region inviting applications from the intending operators on the Shellsham route. And on the basis of that notification, intending applicants made the application. That application was placed in the board meeting, page number 24. Page number 24.
Yes.
And agenda number 3, 10 page at the bottom 3. The discussion on report of MBI technical. Before placing the matter, MBI report was placed regarding seating capacity AC minibus of new AC minibus route. Notification number such and such. The route has been mentioned here. To take this accordingly, the RTA boards scrupulously discussed the matter and accepted the report of MBI technical PPT Kolkata. Next page. Agenda number 4. Hearing of 20 application received in connection with issuance of offer letters in new AC minibus route was taken. The RTA board perused the applications scrupulously and considering all the parameters and decided to issue offer letter depicted below. And the serial number 1 to next page up to next page 20 is the name of the applicant, route number on AC minibus, route submission, bucket number, remarks, approved offer letter. And page number 26. After my lord, this application, the applicants decided applicants appeared before the RT board and were duly heard. The RT board perused the applications scrupulously and considered all the parameters, decided to issue offer letters. Now, my lord, terms of this offer letter decision, offer letter was issued on 2nd February 2021. But according to Rule 141, Rule 141 of the West Bengal Model Treaty, validity of the offer letter is only for 6 months. But all the applicants, that is permit offer letter holders, could not place the vehicle in time because that time the second wave of the COVID-19 situation. Bank loan was sanctioned, could not sanction, and also they cannot arrange the vehicle. For this reason, they applied for extension of the validity of the offer letter. That matter was placed before the board meeting on 10 August 2021, page number 31. And decision taken already page number 32.
32.
32, page number 32. Agenda number 12 and 18 offer letter holders applied for extension of the validity of the offer letter. Who has not applied? One have not applied. 18 offer letter holders applied for extension of the validity of the offer letter. That application was decided to issue fresh offer letters. Decided to issue a fresh offer letter. And after this order, fresh offer letter was issued against the 18 of applicants. Page number 34. Page number 34. Offer letter was issued on 2nd December 2022. In this offer letter, same offer letter was issued against others also. So this offer letter,
34.
first paragraph, this offer letter was issued as per resolution of the dated 10th August 2021 to grant permanent AC special stage garage AC minibus permit for 5 years, and condition AC minibus will be placed. And one of the conditions, very important, that serial number M. Serial number
Yes,
M.
yes.
Seating capacity of AC minibus will be 24 to 35, including driver. It's a 34. Pay number 34. One has got it. Pay number 34. The offer letter, one of the constituting capacity on that. But after receiving this offer letter, what do we place, my lord? The vehicle for registration, pay number 35. Actually, my lord, this is an engine are purchased. It was placed before the body holder for fabricated the body. After making the body, the vehicle is placed before the MB technical for inspection. After inspection, report has been placed for AD technical. AD technical will give the final report. Therefore, it was placed before the registering authority. Then vehicle is registered. Now, after compliance all the formalities, vehicle was registered. And at the bottom, my lord, my shipping classic has been recorded here. Middle portion at the last RC book, sitting capacity 33. One has got it. 10 or 35.
Yes.
Last page, sitting are 34. And also by our wheelbase, the left side, my lord, the right side wheelbase 4235. That is minibus wheelbase. And also sitting capacity of 33 within the the terms and conditions of the offer letter. The sitting capacity will be, but when limited, will be from 24 to 35. Our sitting are 33. That is permissible limit. After registration of this vehicle, permit was issued. Pay note 36. Pay note 36. AC minibus has been recorded here. AC minibus. Our offer letter is also issued against the AC minibus, not bus.
Yes.
And this permit was valid till 11 May 2020. Now, can I say the subject matter of challenge is the petition, the private response. For private, once the two offer letter was issued, page number 54. Page number, sorry, page number 59.
59.
50.
Yes.
A total 18 offer letter was issued in terms of the board meeting dated 10th August 2021, including the private response 6 and 7. Here in this case, the private response 6 and 7, they failed. In the second time also, seeing the second offer letter, they have not complied the terms and conditions offer letter. Again, they applied. Just one day left before expiry of the permit, because valid for 6 months, applied for validity of the offer letter or face offer letter. That application on May 29 July 2000, first line, my lord. This is the offer letter. 29 July 2028-22. And this offer letter was issued in terms of the resolution dated 10th August 2020, 10th August 2021. My application has been made on 29 July 2022 for extension or face offer letter. And this offer letter was issued on at the top, my lord, the right side. This offer letter was issued on 8 August 2022.
8th August 2022. Yes.
This offer letter was issued in terms of the resolution dated 10 August 2021. But 10th August 2021 already my lord decided to issue offer letter. Offer letter was issued by active board. Now again, only two offer letter, applicants.
They call it a
That
fresh offer letter. Yes.
fresh offer letter. That will be placed before the active board meeting. Here in the secretary issued this offer letter without placing the matter before the active board meeting. Whether the third offer letter will be issued or not, that decision also will be taken by the active board. Because in earlier, kindly look at my lord, earlier resolution that this resolution was taken by active board.
Who is appearing for the private respondents?
My landlord is appearing.
You are for the private respondents?
Yes. And 10th August 2021, page number 31. Now, my lord, here in this case, this offer letter also same condition. This offer letter was issued again the AC special stage carriage minibus. As the first paragraph, I am reading, my lord. With reference to your application dated 29 July 2022 on the subject noted above undersigned is directed to inform you that RTA Kolkata in its meeting held on 10th August 2022 was pleased to grant a permanent AC special space carriage AC minibus permit for 5 years. That is minibus are condition, my lord, last line made roll number M. Seating capacity also same 24 to 35 including driver. These are conditions. What change? Condition of the offer letter has not been changed. Same of conditions offer letter has been issued. Now can you see the page number 61? Now after receiving the offer letter, the private race of 6 and 7, they purchased the chassis of my lord wheelbase at the bottom 16, column number 16. Wheelbase 5200. Our my lord minibus wheelbase 4265. They are the bus, and also technical specification of the manufacturer, which has been issued under section rule 126 of the agencies specified in under rule 126 of the set of the rules. What is the seating capacity of the wheelbase of vehicles like the starting 40 plus D. On page number 69.
Mr. Khan, please take the microphone. Please take the microphone.
Yes. Kindly see the page number 69. With the bus specification. My lord has got it. Page number 69.
Yes.
My lord,
These are the specifications.
Tata Motor Limited, this is the specification has been issued by Tata Motor Limited. My lord, the second column, wheelbase,
Yes.
that the heat 5200, my lord has got it. Initially, my lord 3600, 5200, next 5200 also. Because they are seating capacity on the middle portion, seating capacity, and the right side, seating capacity column 40 plus D. This is the minibus. This is the bus. Seating capacity 40 plus 1 D. But here in the offer letter, that the minibus offer letter was issued for grant of minibus, AC minibus, and seating capacity has been limited within 24 to 35. Against this, my lords, I made an objection. Because we are the permit holder of minibus under the notification. Permit was issued under the notification. That notice was through the lawyer. That notice was issued on behalf of his client. While keeping my application on this representation, can you see the page number 86? This objection was issued. This objection was issued on 15 December 2022. 15 December. Keeping this application pending, with a notification issued by the Principal Secretary, Transport Department, Government of West Bengal, on 31st January 2023, made it, my lord, notification. Whereas the new stage carriage route from 15 number bus stand, Ultalanga to Sapurji at New Town for AC minibus service was formulated by this department's notification number such and such. Whereas the Director, Transport Directorate being acknowledged by the Secretary, Regional Transport Authority, Kolkata, by his memo numbered RTA bus such and such, dated 21st December 2022, has informed that 12 permits have already been issued on the route, but all the 12 buses flying on the strength of those permits have seating capacity more than the prescribed limit. This is untrue information because our permit within the limited, because our seating capacity is 33, because permissible limit from 24 to 35. It was steering was prescribed in the offer letter condition. So on the basis of this report, now decision has been taken where the Transport Directorate has proposed for conversion of the nature of service of the stage carriage routes 15 number bus stand Uttalanga to Sapurji at New Town as AC bus service. And whereas the proposal has been considered and approved by the department in the interest of public service. Now, therefore, in partial notification of notification number such and such, dated 27 November 2020, the governor is hereby pleased to convert the nature of service of the stage carriage route 15 number bus train Ultadanga to Sapurji at New is from AC minibus service to AC bus service. Other terms and conditions will be the same. Only this condition was changed from AC minibus to AC minibus. On which report, now 12, second paragraph, 12 permits have been issued, have their seating capacity more than the prescribed limit. From where they have got it? We have placed the place in terms of the offer letter. After checkup, my vehicle was registered. Thereby, it was endorsed in the permit, in the endorsed of the registration certificate. Here, the untrue informant that all these permit holders place the vehicle more than the prescribed limits seating capacity. Well, without any focus notice, without any checkup, without giving my opportunity, values and natural justice, and on the basis of the untrue information and report, this notification is issued for conversion of the nature of service of the buses from minibus to bus or our minibus in terms of notification. These are policy of the government. This policy was changed without issuing notice, without giving me opportunity. This notification was issued behind our back with the allegation that we have obtained the permit by practicing fraud. That means our seating capacity more than prescribed limit. Recorded in the RC book, that is 33. From minibus to only to provide, to accommodate only the private respondent, because their offer letter was issued to grant a permit against the AC minibus. Offer letter is their condition. They cannot change. If the after conversion, if it is required that the permit will be issued against the bus, fresh offer letter will be for grant of permit against the bus, not AC minibus. But in the offer letter, kindly see the back. Kindly come back at and glance. Kindly see the offer letter of the private respondent. Page number 59. There, first paragraph, permit has been, offer letter was issued in his board meeting dated 10th August, was pleased to grant a permanent AC special stage carriage permit. A seating capacity also will be 24 to 35, including drivers. So I have challenged this notification also, this offer letter also. Right? Now, offer letter was issued in violation of the natural justice because decision will be taken by the active board, because offer letter was already expired. The response 6 and 7 applied for fresh offer letter in third round. Their application has not been placed before the active body. Secretary, in his own capacity, this issue was issued relying the resolution dated 10th August 2000 already issued offer letter. Again, this offer letter, we obtained the permit. Even on that date also, offer letter was issued in favor also response number 6 and 7. In favor response 6 and 7. Now, my lord, and the resolution, the notification which was issued 31st last next year, that also this notification is issued on the basis of untrue information report. So we have also this challenge. Can you set aside this resolution as well as that? This is my submission.
As well as?
These two offer letter, because these two offer letter were issued, my lord, by the secretary. Secretary has no power. That matter has not been placed. This application, their application has not been placed before the active board meeting, because relying on 10th August 2021, this offer letter was issued. In previous occasion, my lord, applied for extension of matter was placed, application was placed before the active board meeting, decided to issue a fresh offer, then offer letter was issued and permit was granted. Here in this case, only two applicants, that is 6 and 7, they failed to place the vehicle. Again, they applied for further extension of their has not been placed before the active order. Secretary on his own capacity. Now the condition issue offer letter that to place the vehicle AC minibus, not bus.
But they purchase their own capacity on their risk. They purchase the vehicle, being the whole wheelbase 50, that is bus, the wheelbase of bus. Sitting cost start from 50, 40. And to accommodate those two persons, the registration of the private 6 and 7, their vehicle was registered. Their vehicle was registered on page number 78. Date of registration, page number 78. My lord, at the middle portion, 30th January 2023. Notification was issued, my lord, 31st January, just 1 day before. To accommodate those persons, also recorded here the bus. Though I have challenged only two full grounds. Why you are making the comment? This type of practice should not be allowed. Because I have not finished. I am appearing on behalf of the client.
Absolutely.
You have come the response. I have to maintain the decorum, dignity of the court and so ethics, professional ethics. But other side has no right to make comment. This type. Although I have respect my senior friend, but in this way, because we should শেষ করুন আপনি তো ঘন্টার পর ঘন্টা যখন চালান আমরা কেউ তো কমেন্ট করি না।
Is that all your submission?
Yeah, well, I have challenged these offer letters. These offer letters issued on 8 August 2022 in terms of application dated 19 July 2022 and following the resolution dated 10th August 2021. But that cannot be done because matter was not be placed before the RT board. Secretary on his own risk that the offer letter was issued. This offer letter was issued, my lord, for the grant of minibus. They cannot place the against this operator cannot place the AC. My lord, AC bus. Minibus will be placed. These are conditions.
Your prayer says you have challenged the offer letter of
Offer
8th
letter as well
August.
as the notification both.
8th August and the 31st January notification. both.
This
Yes.
notification was issued on the basis of untrue report against us because our permit has been issued. Yes. Their permit has been issued beyond the seating capacity more than prescribed limit. Converted my 33 within the limit in terms of condition of letter. The limit has been issued from 24 to 35. But there is no answer.
I think you have to continue on some other day.
Yes, yes.
Hearing matter starts at 3:30. Heard learned counsel for the petitioners. Let the matter appear under the same heading for further consideration. On 7 July,
No, 7th.
hearing. 3:30 fixes over. 3:30 বলে আছে। লিখে দিন তাহলে।
fixed matter, item number 134.
Yes. Mr. Mukherjee has concluded on the earlier date.
Yes, my lord.
The respondents are supposed to respond today.
Yes. Now, my lord, what they are doing, they are forcibly constructing the boundary wall over my land. Now, my lord, in the way, let them start at least. You are going on construction, let there be an injunction, my lord, not to raise any construction or not to change the nature and character of the premises of the land.
My lord, I am in possession of some of the properties, my lord, which has been sought for in this.
You are appearing for?
I'm for appearing for the respondent number 11. Now, my lord, in this matter, no construction has been caused. That is something which I can submit, my lord. Whichever, my lord, perhaps the matter can be fixed any day, perhaps tomorrow, subject to Mr. Dotto's.
Present of the writ petition, that's
Absolutely.
recorded already. So,
If the nature and character change,
I will suffer like anything your lordship has got the experience that single matter. Then I have to remove all the things from there. So, my lord, I am asking for self-injunction. Self-injunction. Because I tell you, lordship can recollect this thing. 120.
Well, can there be an undertaking that nature and character of the
Yes.
property will not be
Can-
changed?
Yes.
My lord, that was what the order was of your lordship, my lord, wherein
That is not the
it was observed, my lord, and the parties have agreed that no change in the nature and character to the property would be
Shall I
caused.
record-
But my
shall I
lord,
record
recording,
this?
it's already there.
No, no, this is not already there.
And my lord, in
Then
any
the
event,
What it says that any steps taken by either party pertaining to the
Now they
subsequent
are taking advantage of
shall
it.
abide by the result of the writ petition.
yes.
They are not taking advantage.
Now, my lord, in
Now,
any event,
the matter.
let my learned
Let
senior
me
friend
record
conclude
your
thereafter.
undertaking of both the parties that the nature and character will not be changed.
Yes. Can
Undertaking of both the parties that nature.
My lord,
and
kindly
character-
does not record, kindly takes up the matter
This
tomorrow,
needs
or
to be
let it be
this needs
started,
to
my
be
lord,
recorded.
because I'm not standing in the way. I'm ready and willing for let the arguments be
You are
commenced.
making the submission on behalf of your.
I
client.
am, my lord, but nonetheless, I have derived my title from KMD, Kolkata Metropolitan Development Authority. Now, until and unless they make because they are the most quintessential party, my lord, wherein they need to make submissions, because my title flows from them.
Mr. Pond, since you say that construction is going on, an order of status quo will only help the respondents. They will carry on construction by order of the court.
That is the reason, my lord, not to change the nature and character of the premises. Because, my lord, I am claiming that I am in possession. Now they are claiming, kindly see, my lord, they are saying some of the portion. They are not saying that.
Because I do not represent all the private respondents, my lord. I can make submissions only for myself.
I am asking self-question from myself. That not to change the nature and character, because nobody will going to be prejudiced. Let them continue. On the other hand, they are allowing to.
Also consider this as saying, here the challenge to the action proceeding by a court.
Yes.
Consider granted that protection is enough for them.
Now, my lord,
And my lord, even more.
There has been an acquisition at all is the
Yes.
crux of the matter.
Yes.
Now, my lord, over there's no plea.
my lord, kindly-
So what is the difficulty if the nature and character of the property is not changed? So let there be an order that the nature and character of the property is not changed. That's all.
Now, my lord,
For the time limited period. For the limited period.
They have not prayed for.
This
now, my
is
lord,
not an
today,
interim order, sir. You are.
I'll just indicate one thing, my lord. I'll just indicate one thing. There was an order passed by your lordship, which was varied, altered, my lord, by the appellate bench. Now, thereafter, my lord, the petitioners have come up before your lordship. They have not taken out any application wherefrom they have not pressed for it. They have not pressed for it. They have not pressed for it. They have not sought for any interim order at that given juncture. Now, after 1.5, 2 months of hearing, well, they come up and submit before your lordship that an interim order is required to be passed. Then in that kind of a scenario, in order to cite the urgency, they need to take out an application. The matter is being heard, my lord, over some period of time, my lord. After 1.5 months, 2 months, my lord, they are coming up.
Next Monday,
Next Monday.
the shortest possible date.
Very well.
My lord,
I'm not recording anything because there's a vehement objection to this. So come back on next Monday. 3:30, yes. On prayer of the KMDA, the matter is adjourned. Let the matter appear under the same heading for further consideration on next Monday is 19th. On 19th June, marked at 3:30 PM.
Grateful, my lord.
19th June. 3:30.
Group 1 hearing. Item number 114.
And for the petitioner, your lordship. On the last occasion, there was a direction upon the state to file an affidavit, your lordship. The NHA affidavit we have received. Your lordship, this matter relates to the same point that whether I'm entitled to get compensation under 2013 Act or not. There is no dispute that initially the award copy was not given, but one payment notice was given. And based on that, the arbitration has not taken place for me. In the case of the petitioner, there has been no arbitration till date. Your lordship has passed similar in same moja. I'm giving a copy, I've handed over a copy to my friend as well. If similar direction, because the state has not
given the affidavit till date.
You have received the compensation after 1/1/15.
Yes, my claim is that. Now, your lordship, the fact remains that whether I have been paid after 1/15 or not, that can be decided by the arbitrator. Because what I have got the contention from the affidavit filed by the NHA, they are saying they have made the payment before 1/1/15 to the competent authority. That payment has not come to me because the law says it has to, I have to receive the payment.
No, your lordship. The law now says the Supreme Court's judgment in the case of Indore Development is that the requiring body has to deposit with
Deposit
the
the amount.
acquiring body before 31st December 2014.
But my contention is I have not received before 1st January. And why I'm saying, your lordship, because the arbitrator, the next stage is the arbitration. They has to decide whether, because your lordship can refer this to the arbitrator. Now the arbitrator has changed in this case. I will pray for a fresh application to be before the arbitrator because now the Divisional Commissioner Malda is the arbitrator. At that time, District Magistrate was the arbitrator.
My learned friend's contention is that insofar as the petitioners here are concerned, they were not participants in the arbitration process. They have received the award with the amount which has been determined by the competent authority. Thereafter, whether they have filed any application for enhancement of compensation, that is one question. Secondly, after this, suppose they have already filed an application under section 3G5, whether they were given an opportunity of hearing during the arbitration. That is something which the state will be able to answer whether they were participants or not. Now, if your lordship directs the arbitrator to take into consideration the petitioner's present writ petition and hold a fresh arbitration, then there should also be a direction upon the arbitrator to at least check whether these petitioners had participated in the previous arbitration or not.
Yes, your lordship.
The affidavit in opposition doesn't say anything?
State has not filed any
State
opposition.
has not filed any opposition.
Yes, Mr. Mondal, you don't intend to file an opposition?
Lots of liberty to file the petitioner, Miller, to file the 3G5 application before the arbitrator. There is no need.
Mr. Mondal wants to cut the matter short.
Your lordship, this is an old pending matter because now, because that is not going to harm the interest of any of the parties, your lordship. The arbitrator
And that
has,
application will be considered in accordance with law.
So you admit that there has been no earlier application under 3G5?
Lordship.
You admit that?
page 56 is my representation that has not been dealt with.
Without any affidavit, all that I'm praying for is let the arbitrator decide that issue as well.
Yes,
Whether
yes,
these
right.
petitioners had been represented earlier or not, that's all.
That, your lordship, that can be done
If they
because
have not, then let the arbitration go on. There is no difficulty on that.
your lordship, as your lordship is well aware, how the arbitration was Moja wise. It all that if your friend can produce the copy of the arbitration award, definitely it will be written. It
And the
implies
state
to,
is not able to produce any document to show that the petitioners were represented. So let there be an
They are not.
application.
Let the file now.
State has not even cared to file an affidavit. So it all goes in favor of the petitioner, isn't it? Let there be a similar order.
yes, that
Have you seen this order earlier also? Heard learned counsels for the parties. The petitioner complains that though her land was acquired by the state respondents, by the National Highways Authority. It was acquired by the state respondents.
By the state respondents at the instance of the.
By the state respondents at the instance of the National Highways Authority of India, comma. And compensation was paid to the petitioners after coming into effect of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013.
It may also be recorded that National Highway had deposited the compensation.
I'll record your submission also. The petitioner claims to be entitled to compensation in terms of the Act of 2013. The petitioner seeks to submit an application under section 3G5 of the Act of 1956 before the learned arbitrator and prays for a direction upon the learned arbitrator to consider the said application in terms of the Act of 2013 as well as the Arbitration and Conciliation Act 1996. Upon affording reasonable opportunity of hearing to the petitioner. Paragraph. Learned Counsel for the National Highways Authority of India submits that the entire amount of compensation was submitted by the authority before the state respondents prior to 1st January 2015, and as such, comma, the petitioner is not entitled to compensation under the Act of 2013. Stop. Paragraph. Learned Counsel for the state respondents submits that the petitioner may file an application under section 3G5 of the National Highways Act 1956 before the learned arbitrator, who may consider the same in accordance with law. Paragraph. It appears from the record that the arbitral proceedings has been referred to in your report.
Yes, Your Lord.
The report in the form of affidavit submitted on behalf of the National Highways Authority of India indicates that where is the
Page
page?
3, Your Lordship, paragraph E. That is paragraph 2E. Yeah, what has been published on 14th August 2014.
That an arbitration proceeding was held under section 3G5 of the Act of 1956 by the learned arbitrator, and award was published on August 14, 2014. Stop. But there is nothing on record to suggest that the petitioner was served notice of the said arbitration or was granted an opportunity to participate in the said proceeding. Paragraph. In view of the above, this court is inclined to hold that the petitioner be permitted to file an application under section 3G5 of the Act of 1956 before the learned arbitrator within 7 days?
Within 2 weeks, Your Lordship.
Within 2 weeks from date. Stop. The learned arbitrator is directed to consider and dispose of the said application within 1 month?
Lordship.
Within 1 month from the date of communication.
Your
of this
Lordship,
order.
one submission on the last occasion, it was dated 6 months. Now the proceeding is still going on. So 1 month arbitrary, I don't think will be possible because It embarrasses the entire situation.
Mr. Mondal is taking responsibility.
আগেরটা 6 মাসে চলছে কিন্তু এখনো তুমি 1 মাস বলছো।
Shall it be 6
3
months?
months, lots of 3 months.
3 months? Come back in contempt, we'll deal with it. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the learned arbitrator shall be communicated to the petitioner within a week thereof.
Your Lordship, only one number, a 3G, one copy may be served. Because that copy is not served till date. They paid us, but award copy, whatever the calculation they have, they can produce it, because that will be helpful. Calculation sheet টা যেটা থাকে calculation করে টাকাটা দিয়েছো আমার। আমার award copy তুমি তুলো নি? Award copy দেয়নি তো তুলবো কোথা থেকে?
So made an application for award copy.
Normally পাওয়ার কথা।
Application need not be made, sir.
Lots.
So I'll record your submission that you'll petition status submission and include for the letter. Learned counsel undertakes to the state respondents. The state respondents undertake to serve a copy of the award under section 3G1 of the Act of 1956 to the petitioner within 1 week from date.
1 week.
A copy of the award only.
Made an application to the computer.
Not necessary. The law does not call for an application. Within 15 days from the date of receipt of the copy of the award.
No.
From the date of receipt of the copy of the arbitral award. Of the award. Arbitral award.
Your Lordship, item 1114 to 1119, same matter. Only 1119 is related to Nadia district. Rest are Murshidabad.
You want to take back this, you can. You'll need it in other cases.
Yes, I have copy of that.
Disposed of which actually. 1115, same order?
Same order. Your Lordship.
Same one.
The last matter, 3611115 is the same.
1115, 1116. And 1117.
18.
18.
18.
119.
Same order, 11.
If 119, the matter which is pertaining to Nadia district.
Nadia.
Insofar as these two mojas are concerned, Debogram and Pochachatpur, after the arbitration was held, the
119. 18 of the same order.
after arbitration, Your Lordship, the arbitration award was challenged by NHAI before the district court at Krishnanagar. The order was partially, the application was partially allowed. Now that has again been challenged by National Highway Authority under section 37 of the Arbitration Act, which is pending before this High Court.
But the petitioner was not a party.
Petitioner was not a party.
Party ছিল না।
Insofar as the petitioner is concerned, he deserves a fresh arbitration.
So that comes to the same order again.
Yes, Your Lordship.
And you are again, you have not received it prior to 1115.
No, I am not.
Your contention is the same in this
Contention
matter.
is-
Contention is also the same. The award has, the amount has been deposited prior to 31st December 2014.
Because what you say has no bearing with the present writ
Absolutely.
petition.
Insofar as the petitioner is concerned, he was not a participant. He is entitled to arbitration. He can file a fresh section.
Because there are several arbitration proceedings which may have been challenged by the authority.
Your
So,
Lordship, initially what happened was they had hold arbitration during the mojas. Out of 600 people, maybe 100, 104 has participated. There is recorded in the order and they have passed the.
say it's applicable for everyone in the
Yes,
said
and
matter.
on the last line, they put this
Yeah.
one, for the interest of justice is applicable to all.
We have come across this in several
Those who have not
matters.
participated, the award has been made applicable to them.
We've come across this in several matters.
Yes.
That cannot be done. So the same order be passed. And please give a copy of the award to this, in this matter also.
এটা ডিভিশনাল কমিশনার কোথায় নদিয়া?
না, এটা district magistrate Nadia.
a district magistrate.
অর্ডারের কপিটা যে অর্ডারের কপিটা এক্ষুনি ফেরত দিলাম ওটা ফার্স্ট ফাইলটাতে রাখবো দেখি আগের একটা জাজমেন্টের কপি ফেরত দিলাম না let it remain with the first part to the yes next
Hundred and 20.
I am for the petitioner, my lord. My lord, Mr. Mahato is appearing for the state, my lord. This is the, my lord, Mr. Roy has already concluded his argument, my lord. Mr. Mahato was supposed to, my lord, start his argument, my lord. My lord, kindly considers, my lord, the dates taken out, the number of times the matter. I informed. My lord, senior is here.
yes Mr. Mahato ready
My lord.
yes
আজকে আপনার hearing, আপনার বলো।
My lord, kindly see, my lord, the land has been acquired. And in my affidavit in petition.
it will take some time you're asking for release of other matters
Yes, four.
this has to be recorded liberty is granted on prayer
On the prayer of Mr. Pan.
other matters released for the day for the day in that case Mr. Roy will you please recapitulate in
Yes,
nutshell
Sir, একটু জশকে আমি বলে দিই তাহলে এটা সুবিধা হবে। মানে initially proceedings was initiated under section 3 subsection 1 of Act of 1948. Before going to the other aspect, my lord, I am drawing your attention to the gazette itself, page 43.
yes that's the section 4 notice
3.1. After that, your lordship will find, whereas such and such areas, more or less, section 3.1 was the person authorized, subsection 3.1a of the Act for the public purpose and maintaining supplies nature given is pursuant to the section 4 of the Act. 3.1 notice was issued. After that, my lord, 4.1 for the public purpose. Page 43, my lord.
43 is the section 4 notice
Yes, 4.1a. Initially 3.1a notice was issued for the take-up, and this 4.1a notice was issued under the Act 2. Now, my lord, pause there for a moment, and my lord kindly turn to the order which was passed by my lord Justice Kabir, as his lordship then was, while that my lord kindly turn to page 31.
yes
19th November 1993, my lord got it. I'll read out from because it entire thing has been narrated, so it will be easier for the writ petitioner filed this writ petition challenging an order dated such and such, issued by the collector under subsection 1 of section 3 of the West Bengal Land Acquisition Act 1948, requisitioning the land in question for the establishment of a market in the said land. He said order which was been made annexure 1 to the writ application. This indicates further that the position of the land was taken to have been taken over on 26 November 1993. Appearing for the writ petition, Mr. Such and such submits that the impugned order could not have been sustained on several grounds. Mr. Roy urged that since the land in question were to be requisitioned on behalf of and at the instance of Barupur municipality, this decision could have been done in keeping with the provision of section 9B of the 98 of the Municipal Act, which provides for the acquisition of land on behalf of the municipality only under the provision of the Land Acquisition Act. Mr. Roy urged that the proceedings requisition and acquisition have been taken under the West Bengal Requisition Acquisition Act 1948 and after revert to the Act 2 of 1948. The same were bad and without authority of law, and all order passed there to liable to be quashed. Then, my lord, the submission was recorded. I am not disturbing your lordship. Now, my lord, can you turn to the page 36?
Yes.
The learned government pleader urged, my lord got it from the middle portion. The land in question were to be requisitioned thereafter acquired for the public purpose with the meaning of subsection 1, section 3, Act 2 of 1948. And since there are no irregularity in initiating the proceedings for such requisition and acquisition, the impugned order of requisition was not capable of being questioned, and the writ petition was liable to be dismissed on dismissed with cost. On behalf of the municipality, it was urged that Mr. Bhattacharya, you have the decision of such and such, government pleader, actually accepted the argument. As a service of notice of the proceedings and order requisition, I am not also disputed the same. But ultimate portion is the order where their lordship was pleased to direct the authority to conclude the proceedings. That, my lord, will find page 41. In effect, the object of Act 2 of 1948 is entirely to provide the requisition and speedy acquisition of land for purpose of maintaining supplies and services essential to life and community, which is the object of the instant case. In view of the matter, the respondents, apart from taking steps for requisition in the land, ought to have taken further steps to acquire the same in keeping with provision of section 4 of the said act, which provides acquisition of the land in respect of which an order is made under subsection 1 of section 3. Accordingly, without interfering with the impugned order, requisition under subsection 1 of section 3, it will dispose of the application with the direction to the land acquisition collector, such and such, the other concerned respondent to take steps for acquisition of the property in question within 2 months from the date of communication during the interim, in the period. So, this direction was given to complete the acquisition proceedings. Now, my lord, kindly turn to page 43. This is the 418 notice I have drawn to your lordship attention. Our case is that save and accept issuance this 418 notice. No compensation was paid, no award was declared in view of section 11 capital. Now, my lord, kindly takes up the opposition which was filed by my learned senior friend in connection with this.
Yes. You refer to 4D, isn't it, of the opposition?
Yes.
Paragraph 4D.
Requisition under section 3(1)(a), my lord, I am not disputing the same. Was issued on 1911-19 position of the areas. Both Moses were handed over to RB. Notification for an area such and such was published in Calcutta Gazette. Copies of the notification to the Gazette notification and annexed here 2 marks, which have been drawn to your lordship attention. For the purpose of 80% ad hoc estimate was prepared and fund amounting to such as placed by the RB was deposited to PL account, but no payment could be made due to complication of this rate report. My lord, kindly, this is the admitted fact. Be as if whether 30% or 80%, 90% given to the authority for disbursement, but no award declared. Further, it can be stated that the Badipur municipality initiated a plan to purchase the unacquired portion as well as the land under the purview of notice under section 4(1)(a) of the Act 2 of 1940, as appears from the letter sent by chairman who such an address to the collector such and such. It appears from the record the collector in letter dated such and such reacted upon getting the information regarding agreement for purchase of the land directly from the owners, the land affected in the acquisition, and also payment in advance. 9 lakhs out of the total consideration 60 lakhs for the proposed purchase of land which is viewed unlawful. He also clarified the legal position against the entering into an agreement for purchasing a land which under purview of section 4(1)(a) of Act 2 of 1948. So initially the portion of the unacquired portion and some portion, the municipality was of the opinion that as agreement will be entered into between the landowner and the municipality so that it can be directly purchased from the landowner. The government came forward and said, though it is some of the plots which you intended to acquire is the subject matter of acquisition under section 4(1)(a) of the notice, so this cannot be done. Very well. Now, my lord, can you turn to I?
The collector South River issued a letter number such and such, communicating the chairman Baripur municipality on the basis of the order dated 31st March 1996 passed by his lordship Honorable Justice Altamas Kovil, which I have drawn to your lordship attention that within 2 months you have to complete the proceedings. In the above referred petition, wherein the requisition order under challenge was upheld and reaction was given upon the collector for order to complete the acquisition proceedings. He also invited a fresh formal proposal for acquisition of land under West Bengal Land Acquisition Amendment Act 1997 from the requiring body as acted as lapsed with effect from 1/4/1997. Therefore, at the date of when the life of that act was there, nothing has been done. So they prayed for a fresh proposal that they can revive it by invoking section 9, subsection B of the Land Amendment of 1990 Land Acquisition Act. Several reminders were issued by the collector to the chairman by minister for sending the aforesaid press proposal for acquisition. It is next, my lord. It is pertinent to mention that it appears from the record the chairman in his letter did such express his strong desire to purchase all the lands, whether acquired or not acquired, and according to him, cost of purchasing the land more economical and then going for acquisition of the same. These are all clarifications made by the collector. Mention.
So they go in for direct purchase.
Yes, nothing has been done. So I have informed that you want to purchase, take it from me directly. State Comfort said, no, it is a subject matter of acquisition clauses within the acquisition. You need not to. So that went back, fall back. Now they said, award cannot be declared. I'll come, my lord, after how it has been since 1996, my lord, today we are in 2023. End. It appears to be recorded letter sent by the chairman Barpur municipality, by such and such, where it categorically stated, as the municipality had already entered into an agreement for purchases, so the question of placement of fund does not arise. So the municipality came forward and said, we will not place any fund. In this court representation being such and such in the man Sukumar Koyal and other, who stated that he would like to refrain himself in the issue, dropping the proceeding acquisition as the matter was sub judice at that time.
But what happens to the order of the court?
Nothing. Nothing. I'll come one by one, my lord. Now, my lord, can you turn to paragraph 8? That with regard to the statement made in paragraph 10 to 17, my lord, pause here for a moment and for the cost of repetition, I draw your lordship attention to paragraph 10 and 17 of my writ application. Paragraph 12 is the relevant paragraph. It stated, though the acquisition order under section 4 of the West Bengal Land Acquisition Act has been passed and same was published in official gazette as such and such, but no compensation has been paid to the owners of the land. Even notice has been served upon the, as per section 7 of the West Bengal Land Acquisition Act 1948, provided compensation under section 7 provides the compensation amount which shall be determined by the collector in the matter in accordance with the principles set out in 7(2)(a), or it has been quoted. It is stated the 7(a) of the Land Acquisition provides collector shall make an award within a period of 3 years from the date of publication of the notice and official gazette under section 4(1)(a). If such award is not made within that period, the aforesaid notice shall lapse. So this is by specific assertion that though the notice or the notification under section 4(1)(a) was published, but the subsequent process was not carried on, in spite of the order passed by the Honorable Court. Honorable Court enlarged the time that within 2 months you have to complete these proceedings. Now, my lord, kindly turn in this context, what is the reply of the state? That is paragraph 8. With regard to the statement made in paragraph 10 to 17, my lord, which includes 12 and 13. Or they said, I deny this, I again repeat and reiterate statement made in paragraph 4 and 7 of the affidavit in opposition. I further like to draw and the Honorable Court regarding the letter dated 12/1/7, which was mentioned earlier, another letter sent by him in reply to several letters issued by the collector inviting fresh formal proposal for 9(3)(b). Act 1 of 1894, the chairman categorically stated that he could not provide any fund for acquisition purpose. Surprisingly, neither any formal proposal for withdrawal, cancellation of the acquisition proceeding, nor in formal proposal 9CB were reciprocated by the chairman of the municipality. Hence, the owners were keeping the land proceedings in advance for such a long period that it does not fall upon the land acquisition authority. All right, I stop here for a moment. It is the state who initiated, it is not under section 94 of the Bengal Municipal Act. It is the duty casted upon the court. My lord, your lordship knows very well, the land acquisition manual provides that unless or until you get the fund from the authority, you should not issue the notice for acquisition. So as on this day, my lord, I put this question to myself, my land was requisitioned under the Land Requisition Acquisition Act by the state. This honorable court directed within 2 months you should complete the proceedings. Nothing has been done. On the contrary, it is admitted by the collector. Yes, no fresh proposal was given by the municipality to initiate proceedings on 9CB. So as on this day, either it declared that the notice issued is lapsed, or they can take proceedings under the new act. These are the two things subject to question, where some of the position still remains with us. I must be candid with your lordship, it is though mentioned in such a fashion, it is delivered to RB, but some portion is still remain with us. I must be candid, otherwise I'll not. So as on this day, either the proceedings or the position which has been taken by the state, I cannot ask the municipality did not come forward at any point of time. State, such position is illegal, or the proceeding initiative is illegal, such declaration, or if they at all want to proceed, they have to initiate proceedings under the new act. In this context, my lord, earlier I have handed over two judgments before your lordship, one delivered by your lordship. One is one was delivered by my lords, and one is Justice Tandon.
Yes.
Considering what is the effect, entire thing was taken into account. That was also relied upon to your lordship. And the ultimate decision, yes, you can retain this position or utilize the same, provided you have to initiate proceedings under the new act. Because, my lord, the judgment which was passed by your lordship is I have lost. I have handed over a copy.
Yeah, I have a copy.
I'll take it.
You want to go through this?
Huh?
You want to go?
No, only for the part of the last portion because I have misplaced, my lord. Sorry, my lord, I should not. But it is my duty to keep it one with me. लिखे रख ये लिखे रख तो WP number C112 of 2014. Yes. May I read out a portion? I have handed. Paragraph 10. Paragraph 11. The position of law has been dealt with by the judgment of state versus Shobita Mondal, which is the division bench judgment regarding the continuation of the proceedings which are initiated before 1997, and what will be the effect of those notices if it is not complied with the relevant position, that within 3 years that have to be published. 9CB. The position in the premises, it can be concluded that in view of the lapse of the acquisition proceedings by operation of law due to non-publication of the award by 31st March 1995, the title of the petition is revived. The plots have been admittedly utilized by the state authorities. In view of this, the petitioner are entitled to get compensation at the present market rate upon initiation of the proceedings under the new act. The authority, the state are liberty to issue proposal, direct purchase. That is their peril. I am not on that. We have initiated, but now it cannot be revived at this stage.
Either way.
So at present, my title over the property revives, or they want to continue with this acquisition proceedings.
Shall we hear the state now?
And another judgment is, my lord. Mahadev Khan, my lord, may I hand over to your lordship? Mahadev Khan. Yes. The same, considering all the judgments.
You have referred to para 48 or 48.
Yes. The entire judgment considered, and it was held that there is no other option, but it will be declared to be less proceedings. And it is admitted by the state that no award could be declared. এই দেখো, তুমি yes বলে আমার বেশি ভয় লাগে।
So that's all for now.
Yes,
Let
my
us hear
lord.
the state.
Let's, in reply, my lord, I'll.
My lord, actually the fact which has been submitted, my lord, everything is correct. According to law, it is the settled position. But the difficulty is this, my lord, the requiring body. Kindly see, my lord, my affidavit in opposition, page 19.
But that is between you and the requiring body.
My lord.
Petitioner has nothing, no role to play.
Petitioner has nothing, my lord. I want one chance, last chance, either this proceeding may be left, declare may be left, and possession be returned to the petitioner, or the principality, if they are intended to purchase according to their letter, several letters. If they wanted to purchase it, let there be direct purchase according to the agreement.
Not according to what that agreement was executed sometimes in 2000. The state come forward and say he did not. So today, my lord, the price which was there at that negotiation at the time of 2000, it is not expected the same price will be based on in the year 2023.
Samantha, I think we need to conclude the matter. So please take necessary instructions and come back. There is
Record
no
this.
use.
We record the. My lord, if they want second initiate proceedings, my lord, what is there? I am not asking anything more. My lord can pass the, if they wishes to continue this position.
If the land is required by the requiring body, that is the biodiesel municipality, he has to place the fund.
And he said that,
He
my
has
lord,
to place the fund, and if it is not, then my lord, it should be, my lord, the.
At the moment, placing of fund is not sufficient because there is no proceeding at all. Yes, the section 4, there has been nothing. So it has automatically lapsed.
Declare that if they wanted.
So two options, either you have to purchase it by, or you have to make a fresh acquisition proceeding under section,
that is what is followed from your lordship.
or return the land. These are the three options that you have.
And that is the judgment which is passed by your lordship.
Direct purchase, 2013 Act, or return.
Actually, the two options. Actually, the two options, one option is that if the requiring body wanted to purchase, he has to purchase directly. Second option is that the otherwise to
Return the land. So I'll record your submission, come back on the next day.
Next week,
record this submission. Otherwise, my lord.
Heard learned counsels for the parties. Paragraph, it is submitted on behalf of the category. Learned counsel for the state respondents candidly submits that the requiring body, that the two options, the requiring body category submits that the two options left to the requiring body, comma, that is the Baruipur municipality.
It is the.
Are as follows, colon dash. Firstly, to take steps for purchase of the land from the petitioner, and secondly, comma, to return the land to the petitioner, since the proceeding under the 1948 Act has lapsed long before.
And I'm entitled to rent compensation, my lord. Though I am in some portion, I am in position, I am not claiming the same.
That is consequential. Let them take a decision first.
That's
Learned
right.
counsel seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading. Please come back before I forget again.
Next Wednesday, my lord, next Wednesday will come at 3:30. So it can be, this is the only thing that he has to submit, nothing more, nothing less. Everything has been placed, everything.
21st June is next Wednesday, 3:30.
3:30. Only these things should be submitted.
21st.
লোকে মারবে 10 মিনিট আগে শেষ হয়ে গেছে It's hot matter, my lord. It will take only 2 minutes. My lord, I may
Much more time.
I may be excused because on my assurance, my lord is of the opinion it will continue up to 4:30. But 10 minutes, it's my fault, my lord.
Cannot go by.
No, as what is followed, my learned friend has come to the conclusion, so there is no further. Otherwise, my lord, it will.
Because Mr. Mahathir did not disclose our instructions.
He started as the opposition. Yes, I am. That's why I have already. Short issue. This is the issue.
Please come back to the instructions.
Grateful to your lordship for your lordship.